Good morning, everybody. Happy Tuesday. Welcome to TCF Live. My name is Dan Soul. I will be your guide through the next 3-hour journey through Courtlandia. Today, we'll start with Judge McNally up in Michigan.
Right? It's a civil infraction.
Yes.
And then they're going to dismiss the misdemeanor. Then that's thrown out for you. Okay? Fair enough? Is that what you want to do?
Yeah.
To that charge, under section 324-48738, how do you plead to that charge, fishing with more than 2 lines in the water? Responsible? It's a responsible plea. Okay. I'll accept your plea. You have a license now?
Yeah.
Can I see it?
Yep.
I'll believe it. I'll believe you.
That's my phone now.
That's all right. I'll believe you. $140. Okay? Go right down the hall. Just make sure you have a license from now on, will you please? Have a good day. 140 is your total. Thank you. I hope they're reminding them down there to fill out their surveys. Lisa, would you call down to the desk and make sure they're inviting people to do that so we have some sample sizes? How you doing, Mr.?
Doing great. How are you, Judge?
Good. We'll have to talk in a second. Do you have a file ready for me? Is that the sentencing, Madrigal?
Yes.
Okay. All right. Give me 1 second here, please. Against Alexander Madrigal, file number 26G306740B. That's the impaired charge. And then I'm also calling the A file, which was a plea to impeding. Your appearance? Sir, your name?
Alexander.
All right, your client pled to impeding traffic on the civil infraction. The speeding was dismissed. He also pled to operating while impaired with the OWI to be dismissed. He was referred for a screening and assessment. Have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
The report is accurate. No corrections.
Anything that you would like to say?
That's the matter for this type of matters. Unremarkable. Mr. Madrigal has no prior criminal records. 34 years old. He's employed. The test results were 0.11 relatively low for this type of event. We would ask the court to consider this maximum cost.
No probation.
Good. That's where the legislature's at on this right now.
They're awful nice. I knew you were going to ask that on this one, and I can't let my fundamental differences get in the way, so I don't disagree with you. Anything you'd like to say, sir? I mean, he's going to do some community service and that type of thing, but I'm not going to place you on probation. Anything you'd like to say, sir?
No, thank you. It's here.
I don't agree with it, but you know what? It doesn't matter what I think. All right. I want you to attend the victims impact panel. That is one night put on by Mothers Against Drunk Drivers, okay? I'm going to order 3 days jail credit, 1 served, 2. I'll let you serve those by way of community service, 16 hours community service. He's right. I cannot find a substantial reason, any reason really, to place you on probation in light of that legislation. So I'm gonna go 300 fines, 450 costs, 75 victims' rights fee, $50 justice assessment. So fines and costs are $875. Screening fee is 60 for $935. You have attorney fees of 40. I'm gonna go light on that, $975. And then $166.57 on the cost of recovery. So that should be 1,075, 1135, 1141.57 on that. Lisa, will you double check that? So you're gonna pay 1141.57. You're gonna do 2 days of community service, which I'm gonna give you until June 20th to pay. And 1 day on the victims, you're gonna go to 1 night victims impact panel. And then I'm gonna order $150 on the impeding. So you have a total here of 150 of 1291.57. Can you pay that today? Or do you need time? How much do you have today?
I'm mother to Alfie pay, but I'm not sure.
Well, can you pay the impeding today? That's 150.
Yes, sir.
Can you pay anything more than that today?
Yes, sir.
How much more?
Probably all of it.
You sure?
Yes.
Okay, your mom's gonna help you out. All right, you have 21 days to appeal, 14 days to apply for a court-appointed lawyer. I wish you well. You're still gonna meet with probation. They're gonna set you up, help you set up the victim impact panel, okay? And tell you where you can do your community service. I wish you well. Good luck. No more though. They're never gonna be this easy again. You understand what I'm saying? You gotta write a letter to the legislature and thank them. Have a good day. Thank you, Mr. Higgins. Good luck, sir. Thank you, man.
Thank you, sir.
All right. Do I have Holland's Logistics president here yet or not?
Yes, he's
I have a-
in.
I have a Motorola that I can't identify.
No, it
We'll
should
see.
say, what is your name on there?
He's got to put his,
His should say Holland Logistics.
Honorable Michael K. McNally's personal meeting room. Host has joined, we'll let them know.
there.
You're
Is
here.
that the Motorola G?
No,
No, this is a iPhone,
Okay, hang on.
Is your name Cedric?
yes.
Okay, I got it.
All right, people against Holland Logistics, 6S118410. Mr. Cedric, there you are. State your name to me, will you please?
Yes, Cedric Holland.
Okay, so you're the president of Holland Logistics, correct?
Correct.
And as I understand it, this has been negotiated where you're gonna, the company's agreed to plead responsible to Overweight with agreed upon fines and costs of $1,900. Is that right?
Yes, sir.
And then you're gonna have 30 days to pay. Do you agree to that?
Yes,
On behalf of the company to the charge of Overweight, responsible or not responsible?
responsible.
Okay, I'm gonna accept the plea. I'll give you until I'll just make it June the 8th for you, $1,900, okay?
Okay,
If you don't have the money, sir, call the court and we'll give you an extension. I'll talk to you online, all right?
okay, can I ask a question?
Sure.
Can we start making payments as of today towards the 1,900, or have to be paid in one lump sum?
Yeah, you can start paying it all now. Is
Okay,
that what you mean?
yes.
You still gonna be able to have it paid in 30 days?
That's why I want to start paying today. If I can start paying today in 30
I'll tell
days.
you- I'll tell you what I'll do.
Yes,
Listen
sir.
to me. I don't, they don't, I can give you more time. Here's what I'm gonna say to you, okay?
Okay,
You pay $300 due each week, okay?
okay,
And I'll have you make your first payment beginning on Monday, which is May the 11th, all right?
okay,
So you're gonna get about 7 weeks roughly to pay that.
not a problem. I appreciate that.
And then if you need more time or you don't have the 300 on any Monday thereafter, you call the court, we'll go on Zoom, okay?
Appreciate it.
All right, and appreciate if you'd fill out that survey. They want us to have, the Supreme Court wants us to have the surveys completed. There's a public satisfaction survey. If you have time, I'd appreciate it. If you don't,
Yes, no,
No worries.
listen, that's the least we can do.
No worries. Good luck. Thank you. Austin James.
Well, real quick, that explains that because we've seen QR codes and stuff with other courts where they've got the survey up, and now we know what that's all about. It's ordered by the Michigan Supreme Court. Good morning once again, everybody. It's TCF Live. My name is Dan. I got Ellie beside me. Happy to have you along for our journey. We'll be doing 3 hours today. Courts are just starting to kick off, so we're going to continue with Judge McNally.
Oh, okay. The officer's not here, right? All right. Where's Austin Messick?
Right here.
Okay, you have to start your video, sir.
I apologize.
It's all right. Okay, Mr. Messick, tell me your name.
Austin Messick.
All right. You got a valid plate now?
Yeah, it just got sent to me 2 days ago.
Case dismissed. The officer failed to appear. I gave him 15 minutes. It's now 21 or 2 minutes into it. You're all set.
I appreciate your honor. Thank you.
Have a great day.
You as
Good
well.
luck.
Thank you very much.
You're welcome. The Motorola, do we know who that is, Lisa?
No, she won't answer my messages. I tried to put her in a breakout room and they won't move.
Motorola Moto G5G, we need you to tell us who you are. We don't know who we're dealing with here. You got to tell us your name. You got to put it on there. And if you can pop in right now and start your video, then we'll at least know you're here and be able to direct you to the right place. You have to unmute too. Unmute and tell me your name. You have to unmute in the bottom left-hand corner of the screen. What are they?
I'm going to remove them.
Yeah. Yeah.
Hopefully when they log back in, they'll see that they have to put their name in.
Okay. Corporal Jacoda and Lieutenant Rembes. Do we know what they're here on? Felonies, I assume.
All flat rock felonies today.
Yeah. Hi guys. How you doing?
The attorneys are talking to the prosecutor.
Okay. Are they here on felonies, both of you?
Yes, sir.
Okay. Good enough. How you doing, Corporal? You're smiling.
It's a good day, sir. It's a good day.
It's a good day. Well, we're
it's
getting
still
to the
early, but
spring
it's a good
anyway.
day.
What's that?
I said it's still early, but it's a good day.
Well, that's good. And let's see, Corporal Shapaniak, we have him on the phone, too, Lisa. John, do me a favor, go get the pre-phone on this gentleman, will you, from his Marlo.
Can you just talk to her?
Yeah,
Yes, sir.
and we'll get you out of here, okay? All right. Nicholas Lynn Powers, come on up to the podium, 260-238-036, A and B. Good morning.
Good morning.
Your name?
Nicholas Powers.
Did they offer you anything?
You know, after we dropped the fishing, we got a license, even though it's only 3 days expired, I wasn't fishing. They're trying to get me on the knock, telling me off that at this time, which is over a week's pay, it's like a $800 charge. And I did tell her.
Should pull that up on the screen for me, will you?
Which one do you want?
Mr. I want the one that's with his name on it. That's gonna tell me the fine. It's a $600 charge. 610. Okay, so you want a formal hearing?
Yes, please.
Okay. When are we gonna do the formal, Lisa?
19th at 10:30.
May 19th at 10:30 will be your date, okay, sir? So you're gonna go down the hall and they're gonna give you a paper notice and then you come back on that date. You do have the right to hire a lawyer if you want.
Public opinion?
No, it's just a civil infraction. I can't appoint on civil infraction.
For a lawyer.
Will you come on back on May the 19th at 10:30? And we'll have the hearing, but still go down and get your paper notice. Any questions?
No, sir.
All right, best of luck. Thanks. You too. Sir, could you come up here and check in with him?
We gotta get the Fulton County Jail that I just tried to call, so hopefully they can them in.
Okay.
Can I bring in a Samsung phone?
Sure. I noticed it's telling them they have to identify themselves, right?
Yes.
I understand what Samsung, we need to know who you are, please. You got to tell us your name and unmute and tell us your name. You got to unmute. Bottom left-hand corner of your screen.
Howard Washington Woods.
Okay. Wait 1 second. Next
Okay,
time
we're
you
just-
check in, you have to have your name on there, okay? We can't read minds. We don't know who's who. If everybody shows up just on with their phones.
Yes, sir. I'm trying to figure out how to do that right now.
Well, we changed it now. So just in the future, you have to do that, okay? What does he
Okay,
have,
thank you.
Lisa?
He has a PCC. We're just waiting on the attorney to log in.
Okay, who's his lawyer?
Mr. Dax, set for 9:15.
Okay,
Judge,
I'm gonna put you back in the waiting room, sir. Okay, just wait there.
and he has
Okay.
2 search warrants. You want him to come in? Or you say you can do it today or tomorrow. You'll be in tomorrow.
yeah, ask him to come in. Charles Ellis Bonds III, 26M658175. Your name?
Charles Bonds.
What's the second charge here, Lisa? I've never seen this. I don't think. No proof of registration, civil infraction. Obviously, I've seen that, but they got the FUG checked. I've never seen the FUG checked. I don't even know what it means. You're
Yeah,
charged with-
We
You
saw that
charged-
when it came in and we weren't sure either.
It looks like you tried to charge him. But I
It
don't know
only
why you
came
checked.
through as one count.
Yeah, I don't know. Anyway, you're charged with unlawful use of a plate. And you have the right to a lawyer if you want one. Otherwise, I can arraign you and send you to the prosecutor. It's up to you. I'm sorry.
No, I'm trying to say.
All right, so on April 19 of 26 at 9:17 PM, it is alleged that you did operate a motor vehicle on I-75 southbound near Sibley and Brownstown, and that you unlawfully used a plate. That is a misdemeanor punishable by up to $100 fines, 90 days jail, costs, or all those. Do you understand that?
Yes, sir.
And did you sign, read, and understand the advice of rights?
Yes.
When you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes, sir.
All right, you still wish to waive your right to a lawyer?
Yes, sir.
Not guilty, please honored. $100 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I think he intended to charge you with the second one, but he checked FUG and I don't have a clue what that means. I don't think it means fugitive. Go outside in the hallway
Yes, sir.
and the prosecutor's gonna call you in, okay? And then you can talk to her.
Yeah.
All right, thanks. And then either way, you're coming back in front of me.
Yes.
All right, friends, all in all, it's a slower morning in Judge McNally's court. Let's change it up a little bit. Let's go to Newaygo County, other side of the state, and see what's going on with Judge Springstead.
26-13735 for sentencing. Prosecution defense was the pre-sentence investigation report. Time you made available to.
Was, Your Honor.
Yes, Judge, it was.
All right. And Mr. Price, I'll give you the opportunity to read the report and discuss it with Ms. Harris.
Yeah, Judge.
Do you have any additions, corrections, or challenges?
We do not.
Anything that you'd like to say on her behalf?
We ask the court to follow the recommendation contained in the file. Alternatively, whether the court will consider giving her credit for time served.
All right. And Ms. Harris, have you had the opportunity to read the report and discuss it with Mr. Price?
Yes.
Do you have any additions, corrections, or challenges to that?
No.
Is there anything that you want to say on your own behalf? Now's your time. No? Okay.
It's up to you, yeah. Tell the judge what your plans are, what you plan on doing, yeah.
Well, after, whenever I get out, I have to go to Mason County and serve time in Mason County. I don't know for how long yet. They're waiting until I get sentenced here. And then my mom said that I can come home and I no longer will be homeless. And that she's gonna help me with doing outpatient rehab and helping me with getting back on my feet. She's got like 2 of my kids. And I can be back with my kids and
Your mom has your kids?
yeah, she's got 2 of them. I have 4 kids.
So in Mason County, what stage is that case at? Have you got a deal yet? Have you been there to do anything on it yet?
No, I had a court date April 14th, but they canceled it.
Okay,
It was the weather, I believe. It was really, really bad.
okay. So you don't know what they're going to do with the other?
No.
All right. All right, Mr. Walberg, any additions, corrections, or challenges?
Nothing.
Anything that you want the court to consider?
Nothing additional.
All right, the court recognizes that the advisory guidelines would suggest a sentence between 0 and 11 months. The court's can exercise my discretion, sentence consistent with the advisory guidelines, consistent with the plea agreement in this case. Be the sentence of the court that this defendant served 82 days in jail with 82 days credit. There's a $68 state cost assessment, $130 crime victims' rights fund fee. Court's going to place her on probation for 2 years. During the terms and conditions of your probation. There's a $30 per month probation oversight fee for regular probation, $60 a month for electronic monitoring. There is also a $60 DNA fee. So here is that would be addressed on probation, or those appearing as highly probable under the core compass needs scale, and it looks like you've got a lot to work on. Housing stability, some work skills, substance abuse, how to better use your time. You kind of need a full revamp, right, don't you?
Yeah. I've been homeless for 5 years. After my dad passed away, my mom, this is the first time my mom's offering me to come home and help me.
Sounds like you burned some bridges there about 5 years ago. Now, when you say that you've been homeless, I mean, is it you're sleeping under bridges, or you're couch surfing, or sleeping in a car?
Couch surfing, house to house, whoever people let me stay.
Until they get tired of you?
Yeah, pretty much.
Yeah. What do you think your chances are of staying off methamphetamine?
Really good, with my mom's, my mom's help and, she goes to church, my grandpa's a preacher, and they want me to start going to church every Sunday and being back with my kids. That's a big thing, because I lost custody of my kids when my dad died, when I started doing drugs.
Okay, sounds like you have to deal with that grief, loss, whatever, and whatever guilt or whatever you feel with the kids before you can kind of really fully tackle the substance abuse issues. Think you can do that?
Yeah, and my mom said she'll make sure she's gonna help me with the outpatient rehab and, getting back and forth and stuff.
Okay. All right, the court will give you 90 days from your release from jail in Mason County to pay your financial assessments. Okay. That is all for today. It's going to take us probably till the afternoon to process the paperwork. And then they'll be contacting Mason County and they'll get you transported over there and see what happens there. All right, that's all. Oh, I'm sorry. You do have the right to make applications for you to clear your conviction and sentence. If you cannot afford an attorney, the court appointed attorney represents you on the appeal. Request for a lawyer must be filed with the court within 42 days.
Alrighty, quick and easy one there in Newaygo County. Let's head a little bit south now, but stay in Michigan. We'll say good morning to Judge Middleton.
Morning, sir.
This is Mr. Carpenter.
Mr. Carpenter, why don't you come in and have a seat? Right next to the, well, why don't you come up to the podium? We'll do it that way, like we're supposed to. And we're already off the side. We're going to start our arraignment docket with Martin Lester Carpenter. The file number is 26683SM. Mr. Carpenter is charged with having no insurance. We get lots of these. Are you Martin Carpenter?
Yes, sir.
No insurance is a misdemeanor. It's punishable by up to a year in jail. I don't think in history of the world anyone ever got a year in jail, but that's the maximum. Carries a minimum fine of $200, a maximum fine of $500. So the lowest fine would be $325 if you include costs. And I always ask this fundamental question: do you have insurance now?
Yes.
Do you have proof of it with you?
Yes, I do.
All right. Who's your insurance carrier?
Progressive.
That seems to be popular. All right, have a seat. We're going to need to contact the prosecutor. There's a lesser charge, which is a civil infraction, which would carry $100 fine and not be a crime. If we can get the prosecutor's consent, perhaps we can dismiss this charge and reduce it to a civil infraction. So have a seat for a moment. We'll see if we can get some help. Our whole new configuration, we were all on the same floor. Prosecutor's office was at the other end of the hall. Prosecutors on two different floors. The floors below us. At least district court is all on the same floor. We've taken all of the third floor, every foot of it. All right, I'll set that aside for a moment. Let's talk to Mr. Peterson, Philip Peterson. Are you Philip Edward Peterson?
Yes.
This is file number 26697SM. You got charged with domestic assault. It's alleged to have occurred in 3 Rivers on April 17th. Complaining witness is listed by initials, so there must be a child. Domestic assault is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. I see that you're here with your lawyer, the esteemed Mr. Ross Truckee. Mr. Truckee, would you simply enter a plea of not guilty and ask me to set an attorney pretrial?
Yes, but we would want to be heard on an amendment to the bond conditions.
I can't address that without the prosecutor being
And it would
present.
simply be to allow family therapy to take place between mother, father, and the complainant.
Well, I'd like to hear what the prosecutor's opinion is, so
I can
we'll
try
show a
to,
plea of not guilty.
would you like me to try to find a prosecutor this morning, Your Honor?
Yes. I will. Now, our next attorney pretrial would be Friday, June 5th, I believe is the date. Are you available that day?
Yes.
All right, let's take a look at the conditions here. You still live at 500 Maple Street?
I'm staying at 504.
All right, just next door
Yes, sir.
because of the no contact provision?
Yes, sir.
I used to deliver newspapers in that neighborhood. My father lived at 700 Maple Street 80 years ago, give or take. I have a picture of my uncle. Over about a 1950 Indian motorcycle parked in front of that house on Maple Street. According to the bond order, you are to not use any alcohol, no contact with ASA. So that person is in 500 and you're in the house next door.
Yes, sir.
How old is that person?
16 and a half.
Ross, I'm willing to hear it, but I don't want to take it up without the prosecutor being present.
Understood.
I also need the prosecutor's help on an insurance case, so I don't know if Abigail, let me see who authorized this, you might have some knowledge of it. Signed by Deborah J. Davis.
I will see who is on the third floor.
All right, second floor. All right, Mr. Cuellar, would you come forward, please? Come right up to the podium if you would. They ended up sitting there because that was a place to sit, but it's actually the prosecutor's side. Good morning, Mr. Cuellar.
Good morning, sir.
This distinguished gentleman next to you is Mr. Keith Stickley. He's the chief public defender. This is file number 26698 SM. You're Bosefus Lee Cuellar.
Yes, sir.
You got charged with domestic assault. That's the last case we just had, was one of those. Domestic assault is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. It would prohibit you from using or possessing a firearm. The complainant is your girlfriend, I guess we'll call her. This allegedly occurred in the city of Three Rivers on April 18th. I'm sure that Mr. Stickley would recommend that you plead not guilty. I had appointed an attorney to help you with this.
Yes,
Set
sir.
it for a pretrial. Is that agreeable with you?
Yes, sir.
Again, there's probably a no contact provision. Where are you staying?
The Three Rivers,
At 7th Street?
10, yep, yes.
All right, where is Emily staying?
Trucker Millie Road in Constantine, or Centerville?
That's where you used to live.
Yes, sir.
All right, plead not guilty. Appoint an attorney. Set an attorney pretrial for June 5th, 2026 at 8:30. Now, I'm gonna have the bailiff take you out to the court office. They're gonna give you some information with your lawyer's name and number on it. Some of this you've been through before, so I want you to call the lawyer, make an appointment to discuss this with him prior to June 5th. You got a little bit of an unpaid fine. You got $50 left on allowing another to violate the motor vehicle code.
I can pay that today.
So stop out at the counter when you check on that too. My goal is to have everybody pay all their unpaid fines and costs by the time I retire in December. So it'll be $12 million of unpaid fines if I can collect it all.
I'll do what I can.
All right, Mr. Cuellar, I don't know anything that happened here, but don't get in any more trouble. You call your lawyer and discuss this. They'll get the police report. Prosecutor will get some input from the complainant. And you'll have your $50 paid and all will be right in the world. All right, you're good to go. All right, well, let's see if any of our other misdemeanors showed up. Jose Morales Garcia. Rebecca Heinrich. Good morning. I think I need some water or something. Good morning. This is the place. We're gonna hit the ground running here in a little bit when we get a prosecutor. You may be convening back here in the jury room. Have you touched base with the prosecutor yet?
No, I don't know where they were.
Well, have a seat in here. When we find one, we'll try to connect you. Yes, everything's a bit disorienting. Tim, I'm gonna squeeze in Lonnie Williams. Not like we don't have a bunch to do, but we got a bit of a lull, and I've got a bench warrant for him. He's at order. Good morning, Deputy Keeley. Could I see Lonnie Daniel Williams in my courtroom? All right, thanks. Bye. All right, Ms. Heinrich. You got a ticket for driving without a valid operator's license. We get lots and lots of those. May be our most common offense. It's a misdemeanor, punishable by up to 90 days in jail and a fine of up to $100. It does carry 2 points and it goes on your driving record. Oh, good, thanks. I saw you showing something to the public defender. Do you have your license back now?
She actually doesn't, Your Honor, but she's in the process of getting a permit. I think she's had it before. So we'd ask that you enter a not guilty plea, give her a little bit of time. I think she can wrap some stuff up prior to coming back.
So you're working on getting your permit?
Yeah, we were hit with a tornado and I just didn't go and finish.
You live on River Drive.
Mhm.
You get it both ways. You get flooded and you get tornadoed when you live on River
Yeah, and
Drive.
surprisingly, we really didn't have any damage besides a broken window and my husband almost getting sucked out the door, but that was about it.
All right, no
Everybody else
license,
got flooded.
but you're working on permit. What does that mean? Have you got an appointment with SOS?
Yeah, I gotta go to the SOS office and do it. I took in a juvenile.
Do you have an appointment or you have to set one up?
I have to set one up again because it was the permit and then.
So you had a permit and it expired?
Mhm.
Okay. That's common too. I call this getting on the driving suspended merry-go-round. You get on it and you can't get off of it. If you get convicted of this no operator's license, it'll go on your driving record and will prohibit you from getting your license for probably 180 days. So what Mr. Stickley proposed was, and I'm sure Mr. George, the city attorney, will agree, we adjourn this about a month and see if you can come in and at least have your permit. There's a charge that Mr. George could amend this to that would not go on your driving record and wouldn't affect your ability to get your driver's license. So how about if we adjourn it?
Yeah.
I'm going to adjourn it to a day that I don't have pre-exam conferences, which would be a even numbered Tuesday. So let's adjourn this to June 2nd. It gives you about 28 days to get your permit. Bring it with you. I gotta get a better system. All right, let's give you 4 weeks. Would you give her a copy of this, please?
Deputy?
Would you please give her a copy of this? All right, Ms. Heinrich, you're good to go.
Thank you. Have a great day.
All right, once again, everybody, good morning. TCF Live on a Cinco de Mayo. Good to have you all here. Let's get out of Michigan. Let's go down to Florida. Say good morning to Wade Mercer.
Because you have two issues. You've got a violation of state probation where you have no bond. That's signed by the circuit judge. This one's signed by Judge Garcia. You've got no bond in that case. We're going to come back to that in just a moment. In addition to that, you have one charge of petty theft. There is probable cause for the petty theft. I'm appointing the public defender's office to represent you in the petty theft, Mr. Pittman. Listen to Mr. McDaniel, and we'll see where we're going to go in the petty theft, and then we'll deal with the violation of probation. Mr. McDaniel. Your Honor, I spoke to Mr. Pittman. He's going to plead no contest to charges listed. The understanding he'll be sentenced to 60 days in jail, 1 day jail credit, adjudicate guilty. He has waived his right to jury trial and call witnesses. This plea can't be used against him at the VOP. However, the incident can be used. That'll resolve this case. Thank you. Mr. Mitchell's had agreeable with the state.
It is, Your Honor.
Thank you. And Mr. Pittman, did you hear that agreement?
Yes, sir.
Mr. Pittman, do you have any questions about that agreement on the misdemeanor?
No, sir.
And is that the plea you would like to enter? Thank you.
Yes, sir.
Mr. Pittman, I'm going to accept your plea of no contest to the charge of petty theft in case number, there's no case number on there. 25593MM. Thank you, Mr. McDaniel. I'm going to adjudicate you guilty of that misdemeanor offense. I'm going to sentence you to 60 days in jail, give you credit for the time that you've already served, which is 1 day. Mr. Pittman, 370 court costs and fines, and there's a condition that the plea will not be used against you in the violation of probation proceedings. That does not prevent the state from using the incident itself. So that takes care of that case. In the violation of probation, yes, ma'am. Is there an agreement for $50 civil judgment on the restitution, Mr. McDaniel? Yes, Your Honor. Mr. Mitchell?
Yes, Your Honor.
So, Mr. Pittman, there's a $50 civil judgment on the restitution. Does that change your mind about wanting to enter the plea?
No, sir.
Okay, so Mr. Pittman, that case is over with, but while you're serving that sentence, we're gonna go ahead and get the VOP moving. So in the violation of probation, I'm gonna appoint you a lawyer if you want one. Would you like to have an attorney appointed to represent you in the VOP?
Yes, sir.
I'm going to appoint the public defender's office to represent you, Mr. Pittman, in the violation of probation. Now listen to Mr. McDaniel, and then I'll see if you have any questions in just a minute. Yeah, we're going to plead not guilty. Yes, it's in the June 4th pretrial docket, and I advise him that the attorney to come visit him prior to that hearing. June 4th, Mr. Mitchell, anything?
No, Your Honor.
So, Mr. Pittman, the attorney will see you before your court date. Do you have any questions, sir?
Yes, sir. I got some questions. I got one question. Was my time running from the day that they put the hold on me for the VOP? Because I just got from Washington County yesterday.
Were you arrested only on this?
No, sir. I was arrested.
If you had local charges, it's up to the judge. You don't have the right to get credit for that time. Some judges may give you credit. The state and your attorney and yourself may reach an agreement to give you credit for that time. So if you're arrested solely on this VOP and this warrant, yes, you will get credit for it. But if you're arrested on other charges also, no, you don't have the right to it. It's just only if the judge agrees and everybody's on the same page. So what will happen to the VOP, I don't know. But what you've got in this case is a 1 day credit. But in our case, you certainly may get the trustee program. I hope you do, and get you some extra game time and to put this all behind you. And when you get through with this, you may have the VOP resolved. I don't know. Okay?
Okay.
All right. Wish you the best, Mr. Pittman. We have Kenneth Guilford next.
Good morning, Devin.
Mr. Guilford, good morning. Mr. Guilford, you're here for first appearance. You've been accused of 1 count of aggravated battery. Mr. Guilford, there is probable cause in the complaint. I've also looked at your criminal history. I think you're entitled to a bond, Mr. Guilford, as far as I can tell. Let me listen to the attorneys, and then we'll make a final decision on your bond. Mr. McDaniel, anything on behalf of Mr. Guilford?
No, Your Honor.
And Mr. Mitchell?
No, Your Honor.
Mr. Guilford, I'm going to set you a $10,000 bond, cash or surety. That means you can go through a bondsman. You'll get a chance to use a phone, sir, in a few minutes to post the bond. Mr. Guilford, I'm also going to have a condition of no contact with the alleged victim. I don't want your situation to get any worse. No contact with that alleged victim while the case is pending. And I'll give you a chance to ask questions in just a second. Lastly, we're going to give you a notice for your court date for
Yes, sir.
June the 2nd at 8:30. The jail will give you that notice in just a minute, Mr. Guilford. Mr. Guilford, do you have any questions?
No, sir. I said that, Mr. Wayne. I know you.
Well, hopefully Mr. Guilford, hopefully you'll get to use phone in a few minutes. Hopefully you post the bond and get out of there. Y'all just stay away from each other while this mess is pending, okay?
Hey, no problem, sir. It wasn't me, so I know what you're saying, sir, but it wasn't me.
Have a good day, Mr. Guilford.
All right, Mr. Mercer.
Sherry Carroll.
Yes, sir.
Ms. Carroll, good morning. Ms. Carroll, you have an out-of-county warrant in Calhoun County. I went and looked on the system this morning to see if there was a bond on that warrant. And the teletype doesn't tell us, but the warrant itself does. There is no bond on it. You're accused of violating your probation there. There's no bond on the warrant. So what that means, ma'am, is you'll be held for Calhoun County. You'll get over there in the next couple of working days. You'll go to another first appearance, but the warrant right now has no bond on it. You have any questions, Ms. Carroll?
Yes, sir.
All right, man. Wish you the best. Sexual, Mr. Tyler, David Tyler.
Morning, sir.
Good morning, Mr. Tyler. This is a charge I don't know if I've ever seen. I had to read the statute. It's sexual cyber harassment. I think it's a pretty new statute in Florida. I read the complaint. There is probable cause, but I'm not sure that the officer has it correct in the degree of the crime. Mr. Mitchell, any input on that?
What degree is it listed? I apologize if I haven't.
He checks the felony box, but it looks to me like your first offense is a misdemeanor unless it meets certain felony criteria where you're trying to get money out of pecuniary gain is what the statute says. So I think your first offense is a misdemeanor unless it meets certain enhancing conditions, which aren't alleged.
That's what I know it to be, at least when it comes to cyber harassment in that situation. I think this is a first degree misdemeanor. We can kind of work out the kinks later if we need to transfer it up. We have no objection just to giving it like a misdemeanor date and a bond.
Mr. McDaniel?
Yeah, I don't want to take the prosecution side on this, but I thought it was based, this is my recollection. I thought it was based on whether it was someone was able to be identified within the videos and the stuff. And I also say that the complaint's not clear that the person is readily visible and identifiable. But so I thought that's what the issue was.
Yeah. Okay. So the statute says, except as provided in subsection B, person who violates this section for purpose of pecuniary or financial gain commits a felony to the third degree, where I would take that to be, I'm going to send this video to somebody unless you pay me. And then above that, it says, except for that, it's a misdemeanor of the first degree. There is a paragraph about you have to be able to identify the person from the video. And so it's an unusual allegation. Trying to see if there specifically says that in here, Mr. McDaniel's point.
And we're just asking for a conditional release. I don't think he has any criminal history, and I've known this guy for 30 years, and so.
The only thing, I didn't mean to interrupt you, Mr. McDaniel. Go ahead.
Yeah, we're just going to ask for conditional release no matter what. The state can figure it out what they're going to do with it, I guess.
The only thing I see is a 1980 DUI in the Escambia County. That's a non-factor for bond purposes. That's what's that? Over 40 years ago. 1981 ag battery, the Escambia County. That's over 40 years ago. That's it. And discharge. So I'm going to treat it as a misdemeanor for bond purposes because I think it is a misdemeanor charge. Now, Mr. Tyler, the clerk's office has to set it up as a felony, I believe. So Don, let me ask this question. He checks felony, but the statute number he cites, he or she, they don't cite the specific subsection. They don't cite the right subsection at all. So you can't go by the statute number. So do you go by felony? The clerk's office is going to go by felony where you check that or what? He's got the right. He's got a subsection, but the subsection he cites isn't the one that tells what's a felony or misdemeanor.
I question whether you have a different complaint than I have out here, because mine has clearly section B. And
well, yeah, no, the section B says this. Section B says, it is becoming a common practice for persons to publish a sexually explicit image of another to internet websites. It goes on to explain it. Section B doesn't tell you which degree crime it is. He should have cited section 3B or 3A, not 1A or 1B. Anyway.
Yeah, I think you're right. Yes, it's going to be a misdemeanor.
So he's going to have to amend this complaint, Mr. Mitchell. I don't see any way around it because the clerk can't tell from the complaint it's just like it's like theft. The theft statute has one section that's misdemeanor, one section third degree felony. It's even got some second degree felonies. And if you just put 812.014, there's no way the clerk's office can know which specific type of theft they want to charge with. This is the same way. So Mr. Tyler, I don't know. I'm not going to give you a court date because I don't know which court date to give you because the complaint's not completed completely accurately. I'm going to treat it for bond, for misdemeanor purposes for bond, and based on your criminal history, I'm going to let you pick between a bond and a conditional release. If you want to post the bond's going to be $2,500. If you want to accept the conditional release, I'm going to offer you a conditional release for the reasons I've said. And you will have a condition of no contact with the alleged victim either way. Mr. Tyler, do you prefer the bond or the conditional release, or do you have questions?
Bond.
I think you want to bond, Young. Your bond's $2,500 cash or surety. Mr. Tyler, with that condition I mentioned, no contact, sir, and you'll get to use the phone in a few minutes. I'm not going to give you a court date because of the uncertainty. So, Mr. Tyler, just make sure the clerk has your address, which right now is that 3rd Avenue address. So that way you'll get your notice when they do send it out, okay?
Yes, sir.
Have a good day, sir.
All right, friends, let me just hit pause here for a minute. Thank you to Austin for bringing attention to me, Florida Statute 784.049. I took that statute, which is long and obviously legally wordy, and fed it into my favorite AI friend, Grok. Super Grok, to be exact. And it did super things, and it summarized it as this. This is the Florida revenge porn sexual cyber harassment law. You commit sexual cyber harassment if all of these are true. 1, you willfully or maliciously publish the image to a website or disseminate it electronically to someone else. So it goes on a website or even texting it to somebody. The image is sexually explicit. The image contains or conveys the person's personal identification information, such as name, address, phone number, email, social security number, date of birth, or even a unique physical description that identifies them. 4, you do it without the person's consent. 5, it goes against their reasonable expectation of privacy. 6, you do it for no legitimate purpose. And 7, you do it with the intent to cause substantial emotional distress. So those are all of the things that have to be true for the charge to stick. First offense, as Judge Mercer said, is actually a misdemeanor up to 1 year in jail and $1,000 fine. Second or subsequent, it elevates to a 3rd-degree felony with up to 5 years in prison and a $5,000 fine. Interestingly enough, the statute also paves way for a civil lawsuit with at least $10,000 in damages. And of course, because government is in partnership with big business, all big internet companies, phone carriers, platforms, etc., have safe harbor from this law. So just to give a little more clarity, since that was new to Judge Mercer, that's what's going on with that. And again, thank you, Austin, for helping out with that. Let's get back to Judge.
Thank you, sir.
Your Honor, that
Yes,
was
sir. We have
2,500.
Mr. Mitchell, 2,500.
Okay.
Check Xavier Livingston. Mr. Livingston, good morning. Mr. Livingston, these are some additional charges that have come in. You've now been accused of an additional charge of shooting into an occupied vehicle, 1 count of aggravated assault with a deadly weapon, and 1 count of discharging a firearm within 1,000 feet of another person. Those are 2 third-degree felonies. The first and third one are, 2 second-degree felonies. The shooting into an occupied vehicle and discharging a firearm are second-degree felonies. Ag assault is a third-degree felony. There is probable cause. This is a separate alleged incident than the one that you're already in jail for. This is a totally separate incident. This supposedly occurred on, let me give you a date. This allegedly occurred on April 29th at 4:17 a.m. This is something that they're saying happened on I-10. So I'm going to have to set your bond in these cases. I know you've already got a bond set for an attempted murder, but you're entitled to a bond on these charges also. Mr. McDaniel, anything regarding bond for Mr. Livingston?
No, Your Honor.
Mr. Mitchell?
Your Honor, I just wanted to bring to your attention also that state probation reached out to us yesterday. They received a complaint regarding his attempted murder charge. So it's very likely that a VOSP warrant will be coming in the following days for him and 25589 CF, I think is the case number, but whichever one he's currently on probation for.
We already have that set to come back next Monday, right?
Yes, I just thought it would be beneficial for Mr. McDaniel to hear that too.
Thank you. Thank you, Mr. Mitchell. So, Mr. Livingston, we're going to set the bond at $25,000 each on the 2 second-degree felonies. The ag assault will have a $10,000 bond. Your total bond from today is $60,000 cash or surety with a condition of no contact with the alleged victim. And well, that doesn't change your status regarding next week. I'm still going to see you next week, and we'll see if there's a bond on the VOP or if there is a VOP warrant. We're also going to give you a notice for all your court dates for the one yesterday as well as today for June 2nd at 8:30. That way we'll go ahead and give you your notice, and I'll see you next Monday, Mr. Livingston, and we'll see if they have a warrant or not. Any questions, sir?
Yeah. Yes, sir.
Okay.
I'm being charged with another crime on the same day I just got accused.
You'll find out. Yeah, this is supposed an incident on I-10 where you allegedly fired a shot into another vehicle on the highway. And according to the complaint, 2 of the people in your car identified you as being the one that fired the shot. That's what the complaint alleges.
All right.
Okay. Have a good day, sir. Willis Dean. Mr. Dean, come on up. State versus Willis Dean. Mr. Dean, you're here because you've been accused of one count of criminal mischief with property damage over $1,000. I read the complaint and I didn't see in there where the basis for the property damage. Mr. Mitchell, did you have any argument or see anything I may have missed, sir?
Just a moment, Your Honor. Not at this time, Your Honor.
Mr. McDaniel, any argument?
Your Honor, just nothing. You said this is a sibling thing going on, I guess, it's a sister, so nothing else.
So, Mr. Dean, I'm going to find probable cause for misdemeanor only. The officer has to allege the basis for the damage. Does he get it from the alleged victim? They may not have estimates at that point of an arrest. I get that, but somebody has to say, I think it's X amount of dollars in damage based on this. And the officer doesn't never mention the damage until the charge point where he says he's charging with more than $1,000 damage. So it's a misdemeanor for bond purposes. You don't have a very good criminal history at all. Your bond's $3,500 cash or surety. You do have a condition of no contact with the alleged victim, and you've got this is right now a felony case. So right now your court date will be June the 2nd at 8:30, but you'll get a chance to use the phone, sir. If you post a bond, just have no contact with the alleged victim. Mr. Dean, do you have any questions?
Yes, sir. I was gonna ask if the officer never made a base, like he never based the amount of damages done to the car. How is it still a felony criminal mischief instead of a misdemeanor?
It's not. I'm finding probable cause for a misdemeanor. I set you a misdemeanor bond.
Oh, okay. Okay. Thank you.
Yes, sir. Have a good day.
You do the same.
Jaden Kennedy.
Thank you.
Mr. Kennedy, good morning. Mr. Kennedy, you're here because you've been accused of one count of trespass in a structure. It looks like a second-degree misdemeanor. Mr. Kennedy, there is probable cause for this charge. I'm appointing the public defender's office to represent you. Please listen to your attorney, Mr. McDaniel.
You always just ask for a bond.
Mr. Mitchell, anything?
No, Your Honor.
Mr. Kennedy, it looks like you just got out of jail in Bay County for a
That's
trespass.
what I wanted to speak about. I've been arrested 4 times in a short period of time frame, and I'm homeless. I've got an SSI check, but it's not made it to me in over a year. So I continuously continue to get arrested for being in a situation in life. If I could just get probation or something and be able to sign probation to where I can go and get my check back started up and better myself, I wouldn't be in these predicaments over and over and over and over and over again.
I don't think I've ever given probation to a homeless person. I don't know how you would do that. How can you supervise them? How would you get in contact with them?
I have an address where I could live.
Yeah.
I have multiple addresses where I could live.
You're gonna-
Fact, I have enough money to buy a trailer owed to me. I just
Well, you're
can't.
gonna get a
I
bond
can't.
today, so you can post the bond and go ahead and get you a living location, get your residence, and we'll see you when you come to court. Your bond's gonna be $3,500, cash or surety, based upon you just getting out of jail for a trespass. You'll get a chance to use the phone to try to post the bond. You'll be released as soon as the bond is posted. Mr. Kennedy, they're also gonna give you a notice for your court date. That way we don't have to mail it to you. Go ahead and put it in your hand, and that court date will be when, Mr. Mitchell? June 1st?
Yes, June 1st.
June 1st at 9 a.m. will be your court date, and they'll give you, just a second.
Go ahead.
I couldn't hear what you were saying because I was talking at the same time, but your court date will be June 1st. Do you have any questions?
Your Honor, Mr. Kennedy, I just spoke to him. I think he just wants to go ahead and resolve this case today. The understanding he's gonna be sentenced to 60 days in the county jail. He'll have 1 day jail credit. He's gonna sign his plea waiver form, waiving his right to jury trial and call witnesses. And I have spoke to him prior to the hearings this morning, and I think he knows this is probably in his best interest.
Mr. Kennedy, I have no problem at all if you want to wait and post bond or try to post bond. And if you don't post the bond, I'll see you in a few days. But if you want to resolve this today, I have no problem with that either. So tell me what you want to do, sir.
Will the time still be rolling regardless?
You're going to get credit for the time you're there either way.
Right.
The difference is
See if I
this.
can bind
The
out.
difference is, okay, fair enough. So you've got the bond, you've got the court date. If he doesn't post bond in a couple of days, let's get him back up once he talks to Mr. McDaniel, okay? Have a good day, sir.
What was his and Mr. Dean's bond again?
$3,500. Both of them were $3,500
Okay.
because of their histories.
Credit and yeah, I'll sign it.
All right, we'll tell the judge. Then.
He'll.
Hey,
no, he's
if
back
I'm
and forth
getting
a couple
my
times.
game
He needs to think about it. If he wants to do it tomorrow, let's do it tomorrow. But we need to give him time to think about it. He's too. What's
Let's
the
just
word?
bring him up tomorrow, Your Honor.
I'm sorry.
Let's just bring him up tomorrow.
That's
He
what
was
we're
just
gonna do.
confused about it, if he was still gonna be getting his game time if he's sitting in jail. And I told him, no, you're not gonna be getting the game time sitting in jail. It's not until you plea out. So that was.
Yeah, he gets credit for time served, but not game time. But we'll see him tomorrow if he wants to resolve it, Mr. McDaniel. That leaves Wayne Gates today. Mr. Gates, good morning. Mr. Gates, you're here because you've been accused of 1 count of felony battery. Mr. Gates, there is probable cause for the charge. It's technically a battery, Mr. Gates. It's not your typical felony battery that you think of. Mr. McDaniel, Mr. Mitchell, y'all may have seen the complaint. I think y'all both have. The allegation is he wiped blood on the mother of his child. That would be a battery, and because he has prior batteries, that would make it a felony battery. The problem is Mr. Gates is on state probation out of Washington County. That's where the difficulties come in. So, Mr. Gates, I'm going to appoint the public defender's officer to represent you for first appearance purposes. Listen to Mr. McDaniel, and we'll see what the state's position is after that.
John, we just asked for a reasonable bond.
Mr. McDaniel.
Mc-
I'm sorry, Mr. Mitchell, I apologize.
What's the case number in Washington County?
22-385 CF.
385 CF. We just request that we hold him for 7 days so that I can get in contact with Washington County, see if they want to revoke his or violate his probation over there.
So, Mr. Gates, I'm going to set you a misdemeanor bond because of the type of battery it is. I think it's technically a battery, if what's alleged is true, but your bond's going to be $2,500 cash or surety. But don't try to post it because of you being on probation. That's why this is so complicated. I'm going to ask Mr. Mitchell to notify the probation office of your arrest. They have 7 days to seek a warrant. We'll see if they get a warrant or not. So because of the new arrest, the judge over there may not sign a warrant. The judge may give you a notice to appear, or the judge may sign a warrant. If they sign a warrant, they'll decide if they're going to put a bond on it or not. So I'll see you in 7 days. Well, I may see you before then if they get a warrant signed before then. But if not, I'll see you next Tuesday. We'll see if they have a warrant and if they do put a bond on it or not at first appearance next Tuesday, but if not before. Mr. Gates, any questions?
Yes, sir. I don't understand how I'm charged with battery and I was assaulted and I called. I mean. Sir,
Let me tell you, let me try to tell you that part of the complaint. The complaint says that you and Mr. Castillo got in an argument or a fight, but after
he
you were
jumped on me.
fighting, and I don't, that very well may be true, but the allegation against you is that afterwards you went up to the mother of your child and you noticed you're bleeding and you wiped some of the blood off of your face onto her face and said, here you go. And then allegedly you admitted to that. That is a battery. Now, if that's true, so neither of you were charged with the fight before then, it appears. The officer doesn't mention charging anybody, but technically that's a battery and you are on probation, so you have reduced rights when you're on probation. So right now you've got no bond until we see what they do, okay?
So I'm held for 7 days?
For 7 days at most. If Washington County comes back tomorrow and tells the prosecutor, here's a warrant judge signed and it's got a $500 bond or whatever the judge does over there, we'll bring you back up as soon as we know that. So 7 days at most. I may see you before then, okay?
Yes, sir.
Have a good day. Yeah, we'll give him a court date once yeah, that also gives time for Mr. Mitchell to look at it and see if it's going to stay in felony court or not. All right, so we've got Mr. McDaniel, we have a couple of cases in the courtroom, and I can't tell from this position whether they have private attorneys or not. None of these had private attorneys. Excuse me, none of these had public defenders. Okay. So we got 3 requests for extension, Mr. McDaniel, but they were all pled without your services at arraignment or pretrial. Must have been arraignment. Mr. McDaniel, anything else from the public defender's office?
No, Your Honor.
And Corporal, anything else from the jail?
No, sir, Your Honor.
And Mr. Mitchell, I know that you got to hang around for these. Mr. Mitchell, anything else you need the jail for? Or Mr. McDaniel?
No, Your Honor.
All right, thank you. Ladies and gentlemen, that concludes first appearances. We do have these other 3 cases. Corporal, is someone waiting on this connection? Does Judge Garcia need this connection today?
Yes, sir, we have some Zooms.
Are they at 9?
Yes.
Okay, what do we have? 8:59. We're going to get off this connection then, ladies and gentlemen. We'll put these other cases on a different Zoom room so we can free up this connection with the jail so Judge Garcia can use it. First appearance court is adjourned.
Thank you.
Alrighty, friends, that brings that to a close for the moment. Let's head over to Texas. Judge West is getting her day started.
I'm gonna wait just a second so the court reporters. Morning.
Good morning.
No.
Yeah, the joke, I won't do that. She's not that there. She's back out. You have. Only left. She managed to have it out. Get on probation.
All right, well, as fascinating as all of the mumbling in the background is, it's not overly engaging for a live stream. So let's go across the hallway to Judge Stevens. We'll come back to Judge West later.
Johnny sent the court
I know, I wish somebody would come in person because we just have writing and then everybody else is live and they can explain. The writing doesn't explain itself. He came in again today without a patch on.
And my understanding is he doesn't have one on today either.
Is that right?
Yes, sir. They had filled out yesterday when I was inside.
I'm sorry. Sit over there.
They specifically stated they've never even had a chance to
See,
test
that's,
a patch.
I know, but I'm about to revoke his bond and put him in jail, but not just on people who's, he due process is, he gets, you're representing? Yeah, you get a chance to question, and that's not happening because nobody shows up, and we just can't do it on a one-sided statement in writing. It has to get tested by cross-examination and things like that. But no, I'm sorry. Everybody else has to follow the rules.
I'm picking up this file from somebody else's caseload judge, and I'll be glad to.
Yeah, we're going to have, it takes a hearing, but it's his word against whoever's saying this, and then this just writing and hearsay is an objection that would be raised, and we just can't make it up out of thin air.
Rest of the week, be back here.
But anyway, we're going to get somebody over here right now and deal with one step at a time, if you know what I mean.
Yes, sir. Thank you.
I understand. David.
Depending upon where it goes, I'll make
David
contact
Rogers.
with John.
He's here, President, Your Honor.
I think Mr. Macon is taking over a court appointed, Mr. Macon's been retained. Is
Yes.
that correct?
Yes.
Yes, that's what I thought.
And I'm not ready.
Where is the defendant? Come forward.
For sure.
I'm sorry, David Rogers, where is he?
Stand up, David.
Come on up. Does he speak English?
Yes, Your Honor.
Okay, he's just having trouble communicating. You're David Lee Rogers?
Yes, sir.
You were charged here with a second-degree felony of aggravated assault with a deadly weapon. And if convicted, you face up to 20 years in prison. So this is a most serious allegation here.
He appears to have picked up at least 2 different misdemeanors while he's been out on bond on this.
Who is Charlatha?
My wife.
Okay, do you know you cannot have any contact with her, even though you're married? You haven't?
No, sir.
Okay, if we find out, your bond would be revoked and you would sit in jail until this thing came to trial, which could be a while.
Back on January 8th of 2025, he made admissions that he was around her. And the court went through extensive explanations about the violations and then ordered that he have a GPS.
And that's what you have?
Yes,
A
ma'am.
GPS device?
Yes.
So what else? You had said something, the state?
Your Honor, since he's gotten this bond, looking over this file coming down, he's picked up 3 additional misdemeanors since this bond was set.
Okay, I don't know anything about that.
I'm showing on the system, Mr. Macon represents him on a DWI from April 26th of 24 and unlawfully carrying a weapon. And I informed Mr. Macon that he has an additional charge coming from February 22nd of this year for assault causing bodily injury.
On whom?
Since it's deferred, I don't have the victim's name on that.
I think it would be important to know.
Yes, sir, I agree.
It could be somebody we know in
Yes,
this
sir.
case.
Yes, sir, I agree. But I don't have that.
On my watch, you're going to pick up all these arrests on my watch? First bond condition, don't commit a crime. That's the very first one, sir. Because it's the most important. And you're going to run up arrests. When did all this occur?
The latest was February 22nd of this year, Judge.
Can I get a charging instrument, a copy of a charging instrument?
That's what was deferred. I don't have that information, Judge.
I don't have anything.
When was it deferred? When was he placed on deferred?
It was sent back for us to get proper, it was a.
Oh,
deferral.
he's not on deferred
No,
adjudication.
It was a
Okay.
deferral from our office.
Yeah, you got to be clear.
And
Deferred,
the listed name.
we use it in different ways.
Sorry, Judge.
That's okay.
The listed name is Damari, spelled Dmauri Fisher.
And what's the charge again?
That's misdemeanor, class A misdemeanor assault.
What's the, can I get a probable cause, by any chance?
If I had it, I'd give it to you, Judge.
What's next on him? He's got 3 of them.
Yes, sir.
Finding out the information's on the 2 misdemeanors.
Those two arise out of the same date, which is April 26, 2024. That is the offense of DWI and apparently was unlawfully carrying a weapon. Is he?
Is also out of when? What day?
2 charges, same date, April 26, 2024.
Okay, that was before he was indicted in this. And before he committed the July 5th.
You're right, Judge. That's staying corrected. Thank you.
What, but you said there was a 3rd one?
That was the one that's been deferred by our office for additional information.
Okay. See, we make a big deal about this.
Yes, sir.
Assaults are just, you're charged with aggravated assault. The problem is you picked up these 2 assaults. DWI on April 26th, and then an assault. No, it's a unlawfully carrying a weapon. While intoxicated. And those were handed up on, those were filed on February 25th, but they were alleged to have been committed, and I guess you were arrested on April 26th of 2024. And then a little over 2 months later, you're charged with this aggravated assault. Can I have, is this a copy for me? Or is this yours?
She got it.
Okay, that's right, she did. What bothers me is handguns are your favorite thing, according to these charges. The misuse of handguns seems to be something that you make mistakes over. Okay. What has happened since July 5th of 2024? Any other charges or arrests according to this?
This is the one that I'm need to do some follow-up from this year, Judge.
And what data do you have that you can tell me now about it?
I've been looking at, there's nothing in there, Judge, that I can share with Your Honor.
Anyway.
I apologize. Seeing the 25 date, I thought it was after the date.
That's okay. Not a problem.
Mistake.
No, we're smelling smoke here. We're looking for the fire.
Yes, sir.
There's too much smoke. And you've done something that you don't want. You've got my attention. Close attention. Okay.
If we reset this for about 2 weeks, I believe I can have follow-up on the other and we can consider the bond at that time.
Well, it's what I'm more interested in is what are we going to do in this case?
So this case has been kind of in a stall process while he was trying to get into Veterans Court. He was declined
Okay.
and you made an order that if that occurred, he had to hire an attorney. He's apparently done that. And it was on a trial docket in March, but we've not had an opportunity to visit with Mr. Macon about the case.
When's the next? When's the next setting? What are we, it was in March, you said? Was the trial?
March was the last setting on the trial docket.
Well, why isn't it just rolling over to the next setting?
We can do that, Judge.
That's what we're gonna do. I want this thing tried as soon as we can. It's now it's headed toward 2 years. And he's got other issues and that's bothersome. Does he have any prior convictions? Looking at the, let's see, public safety report shows nothing. Whether it's
Other than the state of Texas, Judge.
All right, let's put this on the trial document. So we're gonna do.
I'll be in touch with Mr. Ham.
I'll keep it, James.
And is somebody coming?
Yes.
Yeah, just, I want to check in before he leaves in the penalty box. Okay, thank you. Jean-Claude Butler, Jean-Claude?
What
are we doing?
Judge, we're waiting on some medical records. We've issued a subpoena for, need to get a reset on that, please.
So when did they get sent out?
April.
Like last month?
April 8th is when they were.
Last month?
Yes.
What you're saying?
Yes.
Okay. We're going on 1.5 years since this thing's been indicted, and now 1.5 years later, then we start sending out things. No, it's time to go forward. One way or the other, we'll put on the trial.
You have the PC.
I have one.
In terms of my representation, it just began in February, Your Honor. So whatever happened before, I don't know, but I know.
Who is the complainant here? What relationship is Mr. Butler to the complainant? I'm asking you.
My aunt.
Your aunt, okay. You know, you can't have any contact with that person. If you did, you'd go to jail and we'd wait that out until we got to trial.
Specifically, it's his great aunt. It's his grandmother's sister, Judge.
Okay, all right. I'll let you know.
Time of this allegation, she was 83.
83 years of age. 83 years of age?
Yes, sir.
When is that? 83 years of age.
I believe that
she hit herself?
No, that he may have been in a post-ictal state from seizure.
Well, I don't know about that, but apparently
$100 for a pair of jeans.
this is
I wonder if those iron on patches.
the assault is on video.
Yes, sir.
Says that the person was not only elderly, but also disabled.
Yeah, she has dementia. We've been dealing with someone who's got her
Okay,
medical power.
all right, okay. So today, what is it? We'll put it on the trial docket.
That's before.
And that's what, and because of the nature of this, accelerated, I want it in the next month or two, please. And we'll put it first. Get it resigned. Taylor Neville. Get it resigned. Taylor Neville.
You can. Judge, on Ms. Neville, we've engaged the state in some discussion. I've been,
What are we doing today? That's all.
Need to reset, Judge.
Okay. Well, until when and why?
30 days to discuss with my client the essentially the last or best states offer.
Okay, 4 weeks, you got it?
Yeah.
4 weeks, okay. Anybody, what are we, how we doing on probation? We got to go into a trial.
All right, we'll keep an eye on Judge Stevens' court. Let's go back across the hallway to Judge West. They seem to be actually ready to do some business now.
Jermaine Gibson Sr. And Mr. Gibson's has 4 cases set for trial to begin with jury selection next Monday. And what is the announcement?
Your Honor, we're going to ask for a little bit more time. We got supplemental evidence, a notification of it, and then a notification to pick it up yesterday evening. So I haven't even had a chance to review what the supplemental evidence is.
It all came in from the DNA, from the DPS lab concerning the DNA stuff. It's their lab notes and everything that we're now required to give
Okay.
defense, and it just came in. So
Okay.
turn it over as soon as we got it, Judge.
Obviously that's important for Ms. DeLage to go over with you before we go to trial. Is it lengthy? Is it?
It was on a jump drive. I haven't even had a chance to look at it yet.
And I haven't even picked it up yet.
Right. Well, I guess my question, my concern is if it's, you've already received results.
Yes, ma'am.
So it's not new results. It's just their notes and things like that.
All of their bench notes.
Right.
Everything that's required to be.
But there's no change in,
It
or
doesn't
haven't
change-
been new
no.
testing, new results or anything like that. So what I'd like to go ahead and do is, unless I want you to get it, take a look at it today. I'd like to go ahead and number the case, obviously, if we can. And there's some others that are potentially going to go above it anyway, but I don't want to just reset it today based on that. Take a look at it, because if it's not really new results, it's just kind of how they got there, then let me know if you need some more time, but otherwise I'll number the case. Okay, sound good? And is the state ready as well?
Yes, Judge.
Okay, all right. And has there been any change? It looks like the last rejection was for 15 years. In the 2 ag cases with dismissals and the others, is that correct?
Correct, Judge.
No change on any type of want to take any plea agreement, correct? All right, I'll number the case then. Again, if there's something in there that looks like it's going to take more time, then just let me know. Otherwise, I'll.
No problem.
So does that mean that we're gonna keep the same date and then go next week?
Yes, but I have several cases set for each week. It's not just one. And so what we do is we have a pretrial. Some cases please, some cases do need to be reset. And then the ones that I have left after docket today, I will put them in a trial order based on the nature of the case, whether the defendant's in custody or not, how old it is and things like that. So I'll set that trial order as soon as we're done with docket today.
At that time, is that the time that we'll be able, that I'll be able to see exactly what everything they have against me?
Well, in trial, Ms. DeLay should have go
I'm
over
sure there'll be
everything.
some of it, but we're going to go through it.
Yeah, she'll be out there to show you everything they have. If something changes, that based on what you show him, you need to let me know immediately.
I haven't
That should.
seen nothing at all.
All right, well, I'm gonna ask Mr. Lasia if you'll get out there quickly. All that should have been gone over everything before really it was put on the trial
Yes,
docket.
ma'am.
So if you get out there, I need to know that.
Yes.
Okay, thank you.
Thank you, ma'am.
Yes. Mr. Lewis on Paulo Dominguez. Two cases. Good morning. Are you Paulo Dominguez?
Yes, ma'am. Pablo Dominguez, sorry, I cannot hear you too good, ma'am.
Okay, so this is cause numbers 25 DCCR 0764 and 22 40372. I'm going to take judicial notice of the court's files in each of those cases. Mr. Dominguez was evaluated for competency to stand trial by Dr. Hamza. I've received that report dated April 8th of 2026. The finding in that report is that Mr. Dominguez is currently not competent to stand trial and that inpatient treatment for competency restoration would be warranted. Is there any other evidence with regard to competency? So at this time, in each case, I'm going to find that Mr. Dominguez is currently not competent to stand trial, that inpatient restoration program would be called for, and order that he be placed in the appropriate competency restoration facility for a period of not to exceed 120 days from the day he gets to that facility. And then we will await their report. I also have a note that the state was going to either amend.
Yes, Judge, we have to amend the indictment.
It's not done yet.
We're just going to strike language.
In both cases. I have a notation that you guys were going to file an amendment.
I was just going to hold the amendment.
I mean, let's do this since he's not competent. If you can get something filed, that would be cleaner for the file. And if you'll explain, Mr. Dominguez, we're going to send you to a hospital so that you can get better, so and you can understand everything, and then we'll get you back in court after that.
I'm thinking back. I'm gonna talk to him back.
Mr. Parker, you have Justice Lewis.
Justice Lewis.
Good morning.
Thank you.
Good morning, ma'am. Are you Justice Joanna Lewis?
Yes, ma'am.
And Miss Lewis, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. Mr. Parker, will your client waive the formal reading of the motion?
Sure, Your Honor.
Ms. Lewis, in cause number 24, DCCR 0766, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 30th of 2024 for the offense of aggravated assault with a deadly weapon, a second-degree felony, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department January, February, March, June, July, and August of 2025. And is that true or not true? True or not true? Thank you. Count 2 alleges that you failed to provide verification of performing the community service hours as directed. Is that true or not true? Count 3 alleges that you failed to enroll in services at Spindletop as you were ordered. Is that true or not true? And then count 4. Okay, we'll talk about what happened after. So count 4 alleges that you're behind in your court assessed fees. And is that true or not true?
He gave me opportunities.
Okay, so did you enter your pleas of true to counts 1, 2, 3, and 4 freely and voluntarily? And did you plead true to those counts because they're actually true? All right, then I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Is there any evidence that Ms. Lewis is not competent? I find those counts true, find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that today. I'm going to reset your case for sentencing and ask the probation department to do an updated report. That'll give me more information about you and what's been going on with your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, talk to Mr. Parker about that, and he'll present it to me on your behalf when we come back, okay? All right, go back with the bailiff. Mr. Parker on Mercedes Sias to sentencing. I'll get her after. Good morning, ma'am. You're Mercedes Sias?
Yes, ma'am.
And this is 18-29442. And Ms. Sias is on probation for driving while intoxicated with a child under 15 from January 7th of 2019. And it looks like she was previously here, entered pleas of true to counts 1, 2, and 3. I've received an updated report. Has everyone had an opportunity to review that report?
Have your honor. Yes, sir.
Any additions or corrections?
No. Understood.
So the probation actually would have expired January 6th of this year. And the motion is what kept it open. It looks like the defendant receives monthly disability and so had issues obviously paying and finding employment, which are the main allegations. And so I guess, Mr. Smith, it looks like the probation has really one of two ideas for us. What are your thoughts on that?
Judge, I mean, I understand the situation. She was given every opportunity, and I just don't think probation is.
Well, it's either to revoke her or to just let it,
I guess.
let the case to close, because primarily it's the fees and the inability. Everything else has been okay with regard to probation other than that.
Yes.
I don't know that I would be able to make those findings that she could have paid.
Well, I'll just in addition to that, Judge, she is part of she's had jobs and she can't keep them because she has seizures. And that was part of her problem with that, you know, she can't keep the job because of her health condition and
Right.
she can't make it to work. Well, she can't pay. And that's pretty much it. She's told me she's about the seizures for a long time. And
Right. So, I mean, based on the probation department's recommendations and summary here with regard to really kind of an inability to pay and inability at times to find employment, I don't know that I would be able to legally find that she could pay anyway. And so at this time, what I am going to do, Ms. Sias, is allow your case to close with fees owed. That means your probation will be over. All right. You've done everything else it looks like that you're supposed to do. So I appreciate that. And it looks like for the most part, you've done very well. And the issues that caused this case aren't what the issues are now. It's just paying and employment. So your case is over. All right. Good luck to you, ma'am.
thank you, Judge.
Delage on Heriberto Chavez. Okay, never mind. Never mind on that one.
She asked me to text from her case number instead of running the payment.
That's fine. I'll hold it while she's taking care of some of that. Thank you. Mr. Rat.
Alrighty, friends, creeping up on the start of hour 3 already. We're hour 47 into this. Time is flying this morning. But good morning to you, TCF Live on Cinco de Mayo. Let's go back down to Florida. Judge Mercer said he had a couple of other cases, and he restarted his stream. So let's check those out.
And let me make sure we've got Mr. Mitchell. He is with us. So, Mr. Martin, it looks like you're here in this case. You entered a plea of no contest to the charge of no valid driver's license back on March 6th. It looks like I sentenced you to 10 days in jail or a $400 fine. That fine was going to be lowered to $300 if you got a driver's license before the due date, which was yesterday. So you could pay $300, or you could come in today and ask for an extension if you needed one. So my first question I ask everyone, Mr. Martin, is in the 2 months you've had, have you been able to pay anything towards this court cost and fine?
No, sir. It's been hectic trying to look for a job, and plus my aunt just died. I was in Fort Walton for that. And it's just, I just been trying to find a job, and I just got one. I actually start today at 1 o'clock.
You were not working when you came to court and pled then?
No, sir, I was not.
Okay. So what are you asking me to do, Mr. Martin?
I'm just wondering if you can give me at least 10 days. In 10 days, I'll have it and be paid. Maybe even before then.
Tell me what's going to change if I give you 10 days. How's that going to change things?
I'm going to pay the court fine.
How are you going to get the money though to pay it in 10 days?
Job. My job holds a week back on money, my check. So as soon as they hold a week back, I work that, and then I'll be able to pay the fine.
So you think you're going to get a check within, if they hold a week back, how are you going to get a check within 10 days? When's your first paycheck?
Yeah, no, my bad. They're gonna hold a week back, so so it'd be 20 days then. Yeah, my bad.
Okay, so what I'm going to do in your case, Mr. Martin, is Mr. Mitchell, what's the state's position?
We have no objection to an extension. I know you were throwing around 10 or 20 days, maybe 15 days or something like that.
Well, I want to give him enough time. My plan is to give him enough time to do it or do community service, and I'm not going to give another extension. If he either pays it or does community service, I'm fine with that. But if he comes up having done nothing again, it's too late to get your driver's license. You didn't get your driver's license either, right?
No, sir.
So you forget about that. The saving the $100 is gone because you had to do that within 60 days.
Yes, sir.
So what I'm
I
going
gotta
to
pay
do
the full
is
400.
I'm going to give you a 30-day extension.
Yes, sir.
For it to come back to court, Dawn, the closest court date to 30 days from now. If you just go to the 5th of June, is that on a weekday? Okay. So we're going to make it June 4th. It'll be due June 4th, $400, or be in court June 5th to start your 10-day sentence.
It also, my bad.
It's okay.
It also got me in a pickle because I didn't have my social security card, so I had to wait that 2 weeks for them to process all that and get me my card. But I just got my social security card and my everything. I just got into the system up there. I start today at 1 o'clock.
We're going to give you an amended disposition.
Yes, sir.
With the June 4th and June 5th date. If you get it paid by June 4th, great. If you don't, you need to be back in court June 5th at 8:30 to start your 10-day jail sentence. What were you saying, Dawn?
Yes, sir.
I just want it to be in the court file. So whichever is easiest for you. If it's easier just to do a notice, that's fine. As long as the court file reflects that. So, Mr. Mark, we're going to give you that notice, sir. We'll give you a copy of that. We'll get you out of here.
Thank you, Judge Mercer.
Yes, sir. Yes, 400 is the same amount he was originally ordered 2 months ago. If you don't pay it and you don't show up, then that's when the warrant will be issued for your arrest. We're going to give you the community service form also. So you'll have that option if you prefer to do community service at the rate of $15 an hour. That's fine too. That'd be 27 hours. So Mr. Martin, step over here if you will. Megan Lanham. Mr. Mitchell, I believe Ms. Lanham is a similar situation. She's on her way up. This is case 26-70 CT. She appeared before me back on March 2nd, charged with driving license, suspended or revoked knowingly, sentenced to 10 days in jail or a $300 fine because she did not have a public defender fee, apparently. She gets a valid driver's license, it'd be reduced to $200, and that was 2 months ago. So Ms. Lanham, tell me have you paid anything at all towards this?
No, sir. I got fired from my job probably a week or two after I came to court for not being able to work on Sundays because my kids.
Okay, so I'm sorry, they were talking at the same time. Say that again.
I got fired from my job probably a week or two after I came to court because I couldn't work on Sundays for my kids.
Okay. So you haven't paid anything at all?
No, sir.
Did you get a driver's license?
No, sir.
Okay, so what are you asking me for?
I do need an extension. I'm supposed to be starting work on the 25th. I was able to find another job.
The 25th of May?
Yes, sir.
Okay, so Mr. Mitchell, state's position.
We have no objection to an extension.
We're gonna do the same thing we did in the last case. That's gonna give you an extension of approximately 30 days. You also get the opportunity to do community service. There will not be another extension.
Yes, sir.
Either do the community service. If you don't start a job until the 20-something, you almost got to do the community service.
Yes, sir.
Because I don't think you can have time to get it paid.
Yes, sir.
So either do the community service or get it paid by this court date or be in court the next day, which I'm going to give you to start your 10-day jail sentence.
Yes, sir.
Exact same disposition. If you don't show up, you don't get it paid, don't show proof of community service, then there'll be a warrant issued for your arrest and there'll be a 10-day jail sentence, which you will do eventually.
Yes, sir.
Hers would be fewer hours, you're right, because it's. Yeah, 20 hours of community service. We're going to give you that disposition, ma'am, of that new notice for the new court date. Of course, if you get it paid, get the community service turned in, you don't have to come to court.
Yes, sir.
Do you have any questions?
No, sir.
All right, man, we're going to get you that paperwork in just a second. Jumar Manuel. Mr. Manuel is coming up in case 26-41 CT. Mr. Manuel.
Yes, sir.
The first question I have for you is, you were supposed to be here at 8:30. You showed up in the courtroom about 9 o'clock.
Yes, I was running late.
And you're running late. You got a Mariana address. It's not like you're coming from far away. So why are you 30 minutes late for court if you live in Mariana?
I accidentally woke up late as well. Had a long night as well. But I just lost one of my family members, Mr. Mercer.
Okay, so let me get this. Let me get on the record where we stand. So Mr. Manuel was here on March 2nd, 60 days, about 2 months ago. Same thing, 10 days in jail. His fine was only $200 because he had a valid driver's license. Given 60 days to pay it, which was due yesterday, or be in court today. So tell me what you mean by long night. I got to decide if I'm going to add to the fine because you're not showing up for court. Out of 3 people, you're the only one that didn't show up on time. So what do you mean when you say you had a long night last night?
I mean, I just lost my
Last night, you lost a family member?
Yes, sir.
Okay.
That's what.
And that was here in Jackson County?
No, sir. They live in Gaston County.
Okay. What happened? Just on a natural passing, or they died in an accident or something?
Yes, accident.
Okay. I'm sorry to hear that. That's understandable if you've been late. So let's talk about, have you got anything paid towards this $200? You've had the 2 months to do it.
No, sir, I haven't. I just got started with a job. I'm supposed to start Thursday.
Note in the system say that you called last week or yesterday. Someone called on your behalf yesterday. It says she, so I'm assuming it was this young lady with you. That's what the note in the system says. You've got $100 of it. Okay, that's helpful because that cuts it in half. It gets it down. So you can pay $100 today to cut this number in half.
Yes,
okay.
sir.
And then how much time do you need, Mr. Manuel, to pay the other 100?
Probably 10, maybe 15 days, maybe.
If I give you the same amount of time as I gave the other two people, can you get it done in 30 days?
Yes, sir.
And you do have the $100 cash to pay today? Okay. Mr. Mitchell?
No objection to the same extension, Your Honor.
So what we're going to do is, provided the $100 is paid today and the officer show you downstairs, so you can get that done, ma'am, I'm going to grant the same extension, Mr. Manuel, to that you had already, as the other individuals. That's a 30-day extension, or very close to 30 days. We're going to give you a court date to come back to start the 10-day jail sentence. Hopefully that's never going to happen, because you're going to have it paid, so you don't have to come back to court.
Yes,
The court date is only if you need it, Mr. Manuel. And those dates, again,
June 4th to have it paid or be in court on June 5th.
okay, so we're going to give you that in writing. And if you take this downstairs, they'll let you make that $100 payment, ma'am. They'll give you a receipt for that. All you owe is $100. So you got 30 days to pay $100. I'm sorry for your loss. We're going to give you the paperwork. Do you have any questions?
No, sir.
All right, we'll give you that paperwork, Mr. Manuel, and we'll get you out of here in just a second. Please. Thank you. Mr. Mitchell, that's everything I had on my docket this morning. Anything else from the state attorney's office?
No, Your Honor.
Alrighty, friends, TCF Live. It's Cinco de Mayo, and we are about to enter hour 3 of our 3-hour show today. Let's head back up to Michigan. Judge Leah Marie Hakeem. See what's going on with her today.
Calling 25 RV 02361, People versus McDonald.
Your Honor, Susan Donovan here for Mr. McDonald. Mr. McDonald, tell the judge your name, please.
Bear McDonald.
Thank you. Judge, as far as I can tell, he just owes money on this ticket. That
It looks like he paid everything and it's just a $100 benchmark fee. I'm going to waive that fee and close the file.
Oh, perfect. He told me his parents were in the process of paying, so they must have done it. You're all set.
That's all that's left, $100 benchmark fee. I'm just going to waive it.
Thank you, Judge.
You're all set, sir.
Thank you so much.
You're welcome. You can go out, sir.
Oh, okay.
Where are you housed at?
Oh, so.
Let's get you the doctor so we can check your hearing out.
All right, can we have Williams next?
Williams!
All right, so.
Where you are? Oh, I'm sorry, you don't think you called.
It's okay. Calling 19 FR 03861, People versus Williams.
Where you are? Susan Donovan here for Mr. Williams. Mr. Williams, tell the judge your name.
Terrence David Williams.
Thank you. Judge, he's here on this 2019 case. I don't believe he was ever arraigned on it. He told me that he was living in Pennsylvania for a few years, and that's why he didn't know that it was up.
All right.
Judge, for your information also, he's been in the Macomb County Jail, and he had an attempt arson case. He received 12 months in the Macomb County Jail for that, and now he's up to be released, but as often they found this in the system for him.
I'm going to cancel the warrant at this time. Where do you live, sir?
8724 Lake Street,
No, what state?
Michigan.
You're living here now?
Yeah.
All right.
He
was arraigned. He was arraigned in June of 2021.
Okay.
He had a lot of FTAs in 2020. He was arraigned in June of 2020, so we don't need to do the arraignment. He had a bench trial date. You've been here a bunch. He had a bench trial date in January of 2021. Set for a pretrial on July 20th of 2021. He failed to appear September 21st of 2021. They reset him for April 19th of 2022. Got set again for May 10th. And now we're here today. Okay, I'm going to cancel the warrant on the file. Sir, I just need you to appear in court.
Yes, ma'am.
How are we going to make sure that happens?
Now that you guys have my correct address and I'm receiving mail, I should get everything that I need, right?
You should. I'm going to give you a $500 personal bond. This is a traffic matter. I'm going to set a pretrial for June 2nd, 2026 at 8:30 a.m. on Zoom. That Zoom number will be on the disposition sheet when you're released from the jail. Make sure you Zoom into me or appear in my court on June 2nd of 2026, okay?
Okay, thank you, ma'am.
You're all set today.
Yep.
Can we have Andrew White, please?
White?
Hello.
Calling 24-15289, People versus White.
Morning, Your Honor. Susan Dunn.
Hello, Your Honor.
Mr. White for his attorney, for his arraignment this morning. Mr. White, tell the judge your name.
J. Andrew White.
Judge, I don't believe he was ever arraigned for those purposes. We may form a reading stand mute. He is for a court-appointed attorney in this colony.
All right, did you talk to Ms. Dunn today?
Yes.
Did she go over your rights with you?
Yes.
Did you understand all of those rights?
Yes.
Do you have any questions regarding your rights?
No.
I'm going to enter a not guilty plea for purposes of arraignment at this time with regard to bond, Ms. Dunn.
Yes, Your Honor. So this is a 2024 case. He didn't really know anything about it. He didn't intend to ignore this matter. He has 5 children, and who he lives with, him and his wife. He is not working right now. He's looking for new employment. I'm asking for a personal bond.
All right, I am going to give you a $5,000 personal bond.
Thank you.
I'm going to set a probable cause conference of May 13th, 2026 at 8:30 a.m. in person with Judge Choco. It's May 13th, 2026 at 8:30 a.m. And then you'll have an exam date of May 20th, 2026 at 8:30 a.m. also in person with Judge Choco. You're all set today.
Thank you, Your Honor.
Alrighty, friends, hour 3 of TCF Live. It's Cinco de Mayo. I hope you're all having a good day. We weren't even planning this last night, but we were looking through our refrigerator and our pantry, looking at leftovers and stuff we haven't used in a while, and we came up with some weird rice queso Mexican dish thingy that we're going to make tonight. Not even thinking it was Cinco de Mayo today, so it should be fun. But let me know what you're eating tonight. Put that in the chat. We like to talk about food here. Let's stay in Michigan, but let's go back to Judge McNally. Fresh new set of contestants there.
Good morning. Your name, sir? All right, so this complaining witness notified victim, Dodge, victim's advocate, Dodge, and said she did not want to proceed. Only witness aware of. Date also tried calling her twice, so they're moving to nollie process. I'll go ahead and dismiss the case. We need to cancel all the bond conditions here, Lisa. And there's no bond to return. If you are going to get a destruction of prints order, take it to the prosecutor. Just get her to approve it. If you want to hand fill it out, I'll sign it now.
Okay.
Okay?
Order.
Yeah, right down at the end of the hall at the clerk's office.
Okay.
Okay? Congratulations, sir. Good luck to you. Thank you. Brett Norris. Brett Norris, Brett James Norris, 26W709-530. Morning.
Sean Smith on Mr. Norris.
Sir, your name?
Brett Norris.
So did he execute a waiver of the bench trial?
No, you're.
Lisa, are we giving them the waivers of bench trial?
Can we just do a quasi waiver just to see if she shows up or cooperates? Because I think if we move it, that might not be, this is a sleepful case.
What?
Like literally, she says that her sleep was full.
Who's calling the prosecutor here, John? Move that out of the way. Lisa, are we giving
There you
them,
go.
are we giving them waivers of bench trial forms?
Hold on one second. He's asking me a question. Yes, they are in the rooms.
No one's answering.
I need Ms. Alloway and I need Mrs. Mara. So, morning, your appearance. So, what, okay, Mr. Smith is here, his client is here. When they're gonna request a bench trial, can you have them fill out that form, please? Waiver of bench trial. They should be in your. Correct, waiver of jury trial. And then you have to make sure you have no objection. You have to tell me that on your form. No objection to bench trial. It's okay without doing it here. I'm just saying in the future, doing the waiver of jury trial would help me a lot.
I was aware.
So why are we rushing on this? Are we gonna do another pre-trial or what are we gonna do?
He's a reserve officer for Woodhaven and for Huron, and this, he's CPL is now, he also works for security companies. CPL has now been affected. He's gonna lose the job unless they get this thing straightened out. Given the circumstances of the facts of the case, I think an immediate bench trial, prosecutor will be put in a position of contacting, trying to get the person to come in. If they don't show up, just like the last case, well.
Have you talked to the victim?
This case, Your Honor,
She just got back from vacation, so she just did not get a chance.
I have not, Your Honor, just because I did just get back and this was recently heard. And I do not recall right now if anybody in our office has had contact.
Sir, if you waive your right to a jury trial, you're waiving the requirement that 6 people be impaneled, that all 6 would have to agree that you're guilty beyond a reasonable doubt in order for you to be convicted. Do you understand that?
Yes.
By waiving your right to a trial by jury, you understand I will be the one who will solely decide your guilt or innocence?
Yes, sir.
Is that what you wish to do?
Yes.
Anybody force you to do that?
No, sir.
All right, here's what I'm doing. I'm accepting the waiver. We're gonna set a final pre-trial in 2 weeks. That'll be May the 19th. Bench trial will follow in 2 weeks thereafter. What time am I doing my bench trial on, whatever that would be? What would that be? The 2nd, Lisa?
That would be June 2nd.
Yeah, June 2nd, what time?
Do you want to do the afternoon? I don't know how long it'll be.
Do the final pre-trial next week, because I have a huge exam up at Port Huron on the 19th.
Well, then let's do it the 26th. I want to give them time to have the victim here. We'll do the 26th, and then we'll do June 2nd at what time?
Do you want to do afternoon?
Yeah. Is
1
Judge
o'clock.
Hudson gonna be done with her state docket info by then, or
Yeah, right now she doesn't have anything.
June 2nd at 1, May 26th at, can you make it here at 8:30?
Yeah.
May 26th at 8:30, June 2nd at 1. Okay?
Thanks, Judge.
Have a good day. Take care. Thank you. Good luck, sir. Oh, wait a minute. You said something about no objection to travel. Is he leaving the state?
Yes, Your Honor, for the record, I have no objection to the travel dates that the defense counsel provided me. He also provided a confirmation of the flight ticket.
Go where?
You're going to Tampa.
Can leave state to go to Florida between, it looks like May 10th and 16th, right?
Yes, sir.
All right, good enough. I'll grant that permission, sir. All right, you're all set. Thank you. Okay, can I have Kalicki? Nicholas William Kalicki, 26W7095671. All right. Who do I have here, Mr. Graziano?
Your Honor, they just signed in for Mr. Kimball. That was the form you didn't sign.
Yeah. I have to wait for your lawyer. I'm sorry. Nice having you here, counsel.
Thank you.
You too.
I've been watching you on TikTok. It's entertaining.
I'm not trying to be entertaining.
I understand.
I'm not trying to be entertaining, believe me. If you did this, you'd be entertaining too. You follow me?
I get it.
All right, but it's not the intent. Go get your lawyer and I'll get you out of here, Mr. Kalicki. Okay?
Oh.
So we're gonna adjourn this, Lisa. They're gonna talk to adjourn 2 weeks to May 19th.
Oh, okay, we'll get it.
And that's on Kalicki. So what time do you want to do that?
10:45.
At 10:45, okay. Is he coming in?
He didn't answer his phone. He just bothered to see who's.
Ms. Jenkins, have I met you? Talking about the. Have I
Yes,
met
I've
you?
been in your court before, sir.
Okay, I just didn't remember. I've been off the state docket for 4 months.
It's okay.
So I'm trying to get reacclimated here. Good to have you here. Thank you.
Thank you. Thank you. It's good to be here.
Corporal Shapaniak, do you have a case here? I'm not sure what you're waiting on. You've been on there all morning. Did you see your lawyer? All right, just have a seat. We'll go off record here, okay?
Alrighty, friends. Well, he's off record. Let's move along. Our channel's promise of 9 to 11% more, Judge Boyd. Let's go there.
That's. I think Paul,
Morning, Judge.
Good morning.
How you doing, Stephanie?
I'm doing great. How are you doing? Thank you. All right, so I think we've come up with a plan to help you. And when I say we, I mean probation, your attorney, and all of the medical personnel. So there's a couple of things that your attorney is going to want to go over with you today.
Yeah.
And if you can talk to him about the information they're requesting, his brother may or may not have access to that or may have it. Because I think his brother may be his guardian. I'm not 100% sure. And so he may have that information.
I can check, Judge, and if not, I will contact the jail liaison and maybe UHS since I have this to see what we can do. Hopefully the state clerk can call me back because I was trying to see if she's ever screened someone in custody. And then we'd also have to check with SB to see if Mr. Payne can be transported directly. If he can't be transported, maybe that he's his brother or possibly might be somebody who's going to assist, but ideally that's where she's just set up.
Okay. And then I don't know if the jail did any type of assessments.
They took the initial screen, but I think the most current and the one that they would want, because it's asking for daily updates in here, would be UHS, because they're the one giving you medication.
All right.
So maybe with this, I can get some.
Okay. All right. Awesome.
I'll check this.
Oh, thank you. Oh, thank you. And you're looking better too. We're going to try to get you out as quickly as possible. Okay. All right. All right. Thank you, sir.
I'll look in the probation file to see what we have, but
Let's go back.
there are certain medical things that I would not be able to release unless I had some type of subpoena or court orders.
Okay. I'll do a court order. I'll do that right now.
Thank you.
And then you'll get the release. So let me do that right now.
Thank you.
All right. Thank you. All right, Mr. Seeloff, are you ready?
Yes, Your Honor, we're ready. He wants to make an announcement to the court.
All right, and what's your client's name?
Eric Guzman. He has
Okay.
2 charges, possession, by a felon and, a drug case.
All right, yes.
I would like to retain the word.
All right, if you want to hire an attorney, then Ms. Ferguson. Set this in 30 days. Mr. Seeloff, you're still the attorney.
I understand.
Unless he hires one.
I gave him a card of Mr. Young. He is very good. And so hopefully he can, make some arrangements with him.
Right. What date, Ms. Ferguson? June 4th?
June 4th.
Right.
I don't need any further notification, right? I guess.
All right, thank you.
June 4th.
Got it? All right.
Thank you.
You better go back.
Oh, you don't story. Yeah. We're gonna hire. That's the. Somehow go to the right.
Yes.
All right, we'll check back there at some point, perhaps, but let's go back to Judge McNally. They got a new contestant lined up now.
We need the exercise, Judge.
Your name, sir?
Nicholas Colicchio.
We're adjourning this 2 weeks to May 19th, 10:45. That's what you want, right?
Yes, Judge, and may we approach the bench, may stop us tomorrow
Come on.
if we have an issue. Even though we don't think it'd be a
Either way,
significant issue.
I don't think it is.
an issue nonetheless.
I wouldn't have an issue.
I'm just right behind you. I'm sorry. So I was talking to you yesterday, and I just wanted to she had a case in 2022 that represented her in she's been and he's representing.
I don't think it'd be an issue. I wouldn't have a problem.
Nah. I don't even know.
I just want to let you know, she felt compelled, I didn't think that it was an issue anyway.
No,
Okay,
that's okay.
okay, thank you.
All right, so we're gonna adjourn this to May 19th at 10:45, okay?
Thank
You're gonna go down the hall, get your notice. Thank you very much. Have a good day. Thank you. And you have another 1 or 2 for me, Mr.?
One more, Judge, yes.
Okay, I'll wait here if you want. Is that the last one then?
Judge, it will be the last one. Take your break. It's gonna take several minutes.
Take a break?
Yeah, whatever
Okay.
you want to do.
Thanks. I appreciate it, Mr. Graziano.
Even though you don't need my permission, Judge.
All right.
Alrighty, well that was quick. Let's go back down to Texas, Judge West.
Thank you.
I'll email you the.
Thank you. Good morning, sir. You Nevada Bates? And will your client waive the formal reading of the indictment?
Yes, ma'am.
Mr. Bates, in cause number 25 DCCR 0834, you're charged with a first-degree felony offense of aggravated robbery from May 16th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Freely.
And are you pleading guilty because you actually did what they've charged you with?
This week.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Bradford?
I do.
The papers on the tablet, and do you fully understand those papers?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Do you understand that as well?
Yes.
State tenders number 1.
No objections?
It's admitted. Is there any evidence that Mr. Bates is not competent?
No, ma'am.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the first-degree felony offense of aggravated robbery Sentence you in accordance with your agreement to a term of 18 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative finding of a deadly weapon. I'm handing you now the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Radford. And I'm going to sign a dismissal in cause number 25 DCCR 1698 as part of that agreement. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Thank you. It's sticky. I just found another one. Let's see. Mr. Nichols, Mr. Burbank has Raul Carina. We didn't bring him over. Mr. Burbank is still in trial, correct? And he announced that he can be ready if it is set at the top. And what is your announcement?
State's ready.
All
My
right.
understanding that Mr. Frank's been in trial and the court has other stuff as well.
It's a kid case in custody, so it might be up there. We'll see. They've got to be close over there, I would think. But we'll see. Do something else?
Danny Johnson.
Danny. Got it. Danny Johnson.
What's your names?
That's right. I already forgot. It's been 2 whole minutes. Good morning. Are you Danny Johnson?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
You, Your Honor.
Mr. Johnson, in cause number 26, DCCR 0097, the state has elected to proceed on the lesser included offense of a second-degree felony of robbery, and that's from October 23rd of 2025. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely?
I don't know if that lesser included.
I said that.
I'm sorry. I didn't know if I heard it. Apologize.
Did I say it? I said it.
Yeah, you said.
Okay, thank you.
Okay.
At least
Sorry.
somebody's paying attention.
Sorry.
And are you pleading guilty freely and voluntarily to the lesser included offense of robbery?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Johnson's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the second-degree felony offense of robbery. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon. It's a knife. Also, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, sir. You can go back with the baby.
See y'all at 1.
So speaking of armed robbery, join us for Sidebar tonight right here on this channel, 8 p.m. Eastern, 5 p.m. Pacific. We're going to discuss the idea that somebody can be guilty of armed robbery without actually having something like a gun. So that should be fun. Join us there again right here on this channel, 8 p.m. Eastern, 5 p.m. Pacific tonight. Let's go back to Judge Boyd.
All right, court is calling 2020 CR 7507 State versus Desiree Garza. Can I have parties announced?
Derek Emmons from Miss Garza.
And are you Ms. Garza? All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes,
Are you the same Desiree Garza who was placed on deferred adjudication in 2020 CR 7507 for the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams, on May 4th, 2021 for a period of 6 years? Is that you? All right, state.
Violated condition number 2, on or about the 22nd day of August 2025 in Bear County, Texas, the defendant Desiree Garza did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that, true or not true?
Sure. Violated condition number 2, on or about the 18th day of November 2025 in Bear County, Texas, the defendant Desiree Garza did then and there fail to submit to drug testing as directed by the court officer, supervision officer, or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that, true or not true?
Sure. Violated condition number 2, on or about the 9th day of December 2025 in Bear County, Texas, the defendant Desiree Garza did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that, true or not true?
Sure. And finally, violated condition number 2, on or about the 30th day of January 2026 in Bay County, Texas, the defendant Desiree Garza did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that?
Sure. State will waive the remaining allegations.
Any objection to the waivers?
No objections.
All right, and that's for number 2s. All right, did you understand by pleading true to violations 2, 2, 2, and 2, the court can find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true?
Yes.
Court will find 2, 2, 2, and 2 true. Is there a proposed agreement?
Yes, the proposed agreement is to grant state's motion, enter an adjudication of guilt, revoke, and sentence 4 years in the prison. The state will also take into consideration clause number 2026 PF 14573.
Right, did she do any inpatient treatment?
She did, Judge.
Okay. All right, so why is she not testing? This is her 3rd MTR. So can somebody explain to me? All right, if you want to explain, you'll have to raise your hand and I'll take you under oath. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. State your name for the record.
Desiree Garza.
Ms. Garza, the judge asked you a question, why you were not submitting to the UAs. Could you answer the judge why you have not submitted to the UAs or why you missed them? What happened in your life, why that happened?
I was going through a lot at the time and I knew I was dirty and I'm not gonna lie. I knew I was dirty.
So that still doesn't explain why you didn't report, because you have responsibilities. So you were just not following through on anything. And if you've been in inpatient treatment, they've talked to you about what you need to do in order to stay clean and sober. You just choose not to do that. So I don't know why I should give you 4 years. And why it shouldn't be more. But does anybody have an answer for me?
Judge, I understand the court's position. She has been a safety. There's been some expense that the state has put out there for her rehab. Obviously, addiction is a difficult thing people deal with, and is something she has dealt with. One of the recommendations in the probation officer's file was revocation, of course, as well as safety special needs. I guess that's a separate safety program from what she's done before. I've explained to her, Judge, that on a revocation, she's going to be repeated from here on out. She'll have a PDC trip. She's not over probation if she ever gets in trouble again. She just assured me that she has a daughter that started in the military, is about to graduate. This boot camp, I'm assuming. She wants to try to put this behind her. Obviously, her track record is not really showing that she's capable of doing that as of yet. We understand that, Judge. We're asking the court to consider even the 4 years TDC. There's a lot of bite to that because she will be a convicted felon now. She understands that. So she'll try and put this behind her as quick as she can and move forward in a positive direction.
Is this her first felony? And the reason why I asked that, because the plea bargain agreement, the state was silent on your application. And so the court gave you deferred adjudication. And at that time, they were asking that you be sentenced to 2 years in the prison.
Based on looking at the history, Judge, I do not see any family convictions. I do see, however, there have been several arrests that have been held.
All right, this is what the court is going to do. The court is going to grant the motion, find you guilty, revoke, sentence you to 5 years in the prison. Give you credit for any time served. There's to be no unsupervised contact with minors, no residing in households with minors, therapeutic community. And I will give you credit for any successful inpatient treatment completion.
Thank you, Judge.
All right, did you? Yes.
She has a monitor on her ankle as well still. I think the court ordered it from what she shared with me. It's RMS monitor.
They got her they have her with a monitor and while she's at the jail?
Yes, and I've never encountered that before, Judge, but the deputies told me that it happens more often than you thought. I thought I could just call pretrial GPS and have them come removed because maybe they didn't need the monitor for someone else yet. But she's sharing with me that is actually through, which I think is something you might have ordered on her last MTR.
Okay.
You had ordered it when I got released from safety, like relapse.
All right.
Yes.
Ms. Abrams, did we order a monitor for her?
Judge,
Are they letting you charge the monitor at the jail? All right.
it was partially done, after last.
All right. I'll order removal of the monitor.
Thank you, Judge.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question about what that is, you will need to speak to an attorney. Do you understand?
Yes.
And also, you all are taking something in consideration, correct?
Yes, sir. I emailed the intake.
All right. So, and also for the record, taking in consideration 2026 PF 14573. All right, we can go off the record. Here's the thing. If you don't change your life, you know what's going to end up happening? You're going to end up going back and forth to prison, or you may end up somebody identifying your body, because you never know what you're going to get when you're taking drugs. when you're released from, take advantage of the therapeutic community. The therapeutic community doesn't increase the time you're in custody, but it's designed to help you. So what will end up happening, I've ordered it, they're gonna see it on the judgment, but I don't have jurisdiction to force you into that program, so you're gonna have to ask for it as well. When you're released from prison, the first thing you need to do, go to Lifetime Recovery, go to felony drug court, and this is why I'm suggesting you go to felony drug court. Felony drug court will have all the resources for you to get you in an inpatient treatment facility. Do you understand?
Yes.
All right, I don't want to read about you on the news, okay? All right, good luck to you.
Maybe excuse Judge.
Yes. Who's next?
Okay, fix Linda Fargo.
Linda Esparza? Yes.
Back in November. I had not seen her, and it's my understanding she picked up a new case in March. I was under the understanding she was out on bond. She is not. She's incarcerated, and so they were gonna bring her up, and she just had a medical episode, so
Okay.
she's on her way to the hospital. I was asking for a reset.
All right. Ms. Ferguson, on this case, I'm gonna give you a date in June, but if you want her brought back sooner, or you think she can be brought back sooner, just let us know. I'm gonna put it at the end of June.
That clears me of everything, and I'll try to get a hold of her when she's out of the
All right,
hospital.
Ms. Ferguson, end of June? June 29th. All right, June 29th.
Can I just check Tuesday?
Is that a good date for you?
Yes, Your Honor, perfect.
All right, we'll see you back then.
Thank you.
You're welcome.
Maybe excuse.
Yes.
I bet something.
You're back. Thank you.
I'm working on two, please.
All right, thank you. You said June 29th, right?
Yes, sir.
Thanks.
Alrighty, friends, we'll continue to dance around Texas. Let's go back to Judge West.
Joshua Smith. And this is 25 DCCR 1439. And Mr. Smith, in that case, you're charged with a first-degree felony offense of fraudulent use or possession of identifying information, 50 or more. And that is from August 20th of 2025. What that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand? And I have here on the tablet a plea bargain rejection that you've signed with Mr. Lewis that shows that the state's attorney has made an offer if you wanted to enter a plea of guilty for a cap of 10 years in prison, which means you would be leaving your punishment up to me. I could give you 10 years, I could give you less. It would all depend on the information that was brought to me at a sentencing hearing. You have every right to reject that and have a jury decide if you're guilty or not. And then if they find you guilty, you could leave your punishment up to that jury. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial? All right, we'll get that done. And Mr. Smith, Mr. Lewis has been appointed to represent you at this point. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? You'll keep Mr. Lewis? All right, Mr. Lewis will begin preparation for trial then. All right, we'll see you back. And Hakeem Thomas, Mr. Lewis.
Thomas.
Good morning, sir. Are you Hakeem Thomas?
Yes, ma'am.
And this is 25 DCCR 0843. Mr. Thomas is charged with aggravated robbery. And Mr. Lewis, what is the announcement?
Just there should be a rejection
Okay.
that's been filed.
I've been up here, I hadn't had a chance to send it.
Okay,
It's on the
just,
tab.
I need to hold that one for just a minute.
Oh.
Until it comes through. I'll take care of it in just a minute. Mr. Radford, you have Jacoby and Dorsey. Oh, did I lose Mr. Radford? Hold on that one.
I'm here, Judge.
Oh, okay.
So I have one we need to visit about not when everything is muted.
On the docket today?
Yes, ma'am.
Okay,
Mr. Fleming's,
I don't have a Mr. Fleming's on the phone.
Orion Fleming's.
It's not on today's docket. All right, sir, are you Jacoby and Dorsey?
Yes, ma'am.
And this is 25 DCCR 1896. Mr. Dorsey is charged with manslaughter. And what is the announcement?
Judge, Mr. Dorsey was recently bench warranted from TDC.
I see
I
that.
have visited with him initially. I need to get the media. And Mr. Coleman and I have had some initial plea bargain discussions, but I'd like a little more time so that I can get the media, the surveillance videos and go over them with Mr. Dorsey. No objection, Judge.
All right, so Mr. Dorsey, I'll just do a normal reset. That way Mr. Radford can get out there, go over everything that the state has, what their offer is, and if you guys can work it out, great. If not, we'll know what we need to do at that next court date. All right, you can go back with the bailiff. Thank you.
Mr. Fleming.
I don't know anything about it. It's not on my docket.
When is it?
Mr. Reynolds on Carl Ledette. Morning. Morning.
Good morning. Let me excuse Judge.
Yes, thank you.
Oh. Please.
Good morning. Are you Carl Ledette?
Yes, ma'am.
And this is 25 DCCR 0579. And Mr. Ledette is charged with aggravated sexual assault of a child. And Mr. Reynolds, what is the announcement?
Judge, I believe he's previously entered a rejection of 30 years.
Yes.
He'll stand by that. He's asking for a trial.
Okay.
I am the fourth lawyer on this case. It's been going on for over a year.
It has.
So we'd ask it be expedited. There's some media at the DA's office that I believe I could certainly do before the next trial session.
Sounds good. We'll get it set for trial. Nothing's changed, Mr. Ledette, with regard to you wanting to go forward with trial, correct?
Mm-hmm.
And so if one of those things is the guardhouse and y'all need to watch that with Mr. Ledette, get with Ms. Holmes and she can schedule to have Mr. Ledette brought over. You guys can use the jury room here. The state can bring down that video, since you're not allowed to take it.
Okay.
And y'all can watch it here in the jury room.
Okay, thank you.
But in the next couple of weeks, just get with her and she'll schedule that to have them brought over.
Yes,
All right. All right. You can go back with the bailiff. Thank you. Yes, ma'am.
Thank you, Judge.
Yes,
It's
sir.
my own case.
Yes, thank you. Have a good day. Mr. Wilkerson on Tyree Hartley. Good morning. Good morning, sir. Are you Tyree Hartley?
Yes, ma'am.
This is 25 BCCR 0842. Mr. Hartley's charged with aggravated robbery, and what is the announcement?
Judge, this is gonna be a trial case. If you recall, we were waiting on some additional discovery materials from last time. I did receive some additional materials. I believe the state is still working to secure the videos from Chambers County related to the actual stop. But again, similar to last time, I don't think it's going
It's
to
gonna change
change
anything.
anything.
So it looks like the previous offer, Mr. Hartley, we've already gone over that if you're found guilty, you would be considered a habitual offender if those prior convictions are true, which would mean a minimum 25 years. It looks like the offer was for 20 years on count one, and you are ready to go forward with trial. Is that correct?
No.
Okay, we'll get it set on the trial docket. Obviously, the quicker, I know you're waiting on them, Mr. Nichols, but if you'll let them know it's now on the trial docket, it would be important to get that as quickly as possible.
Yes, sir.
All right, thanks, y'all. You can go back with bailiff.
Thank you, Judge.
Thank you. And then you've got John Jones.
Yes, sir. Yes, ma'am. Can we hold that one?
Sure.
Just one, thanks.
Yes.
Hold on.
I think this is one that we got, John Jones. Yeah, this one doesn't surprise me, but that's freezing. But still.
Oh, she's muted, friends. We might. Well, let's wait a minute, see if she unmutes.
All right, are you Heriberto Chavez? And this is 25 DCCR 0559. Mr. Chavez is charged with deadly conduct, discharging a firearm, and what is the announcement?
Your Honor, we were able to meet. We had some trouble. We tried to meet here, found out he was no longer at the unit at LaSalle. He was now in our county court. So then we did a second meeting last week at the county court, went over every bit of his media and paper discovery. He was hoping that the offer would come down just a little bit. It has not. I could not get Ms. Birch here today, so I can't explain all of that to him in detail, but I think we might could get close to an agreement at the next setting.
Okay.
And it could be a quick setting.
Okay. Yeah, and if you have trouble with her, we can get someone else here. Just let us
Okay,
know.
okay.
So we'll reset. Let's just do maybe 3 weeks on that. And that way we'll get somebody here. And we'll have an interpreter. Okay. You can go back with the bailiff.
Thank you.
Thank you very much.
Yes, ma'am.
Appreciate y'all.
Ms. Holmes, you have Therawayne Fields. You still have something? Did I miss you? Oh, okay.
Oh, yeah.
Oh, that's right, the rejection. Good morning.
Good morning.
How are you?
Hello, I'm. This one, if he's still not cooked in.
Oh, okay.
Oh.
He's not here.
Yeah, he's at Russ.
Okay. She's gonna get mad because he's not answering. All right, this is clause number 1829467 on Therawayne Fields. I'm going to take judicial notice of the court's file. And that Mr. Fields has filed a waiver of appearance and trial by jury dated April 28th of 2026. He is currently in state custody based on a competency him not achieving competency yet. Ms. Holmes, do you join in Mr. Fields' waiver of his right for a trial and to be here?
Yes, Your Honor.
All right, so then we'll go forward. I'm also going to take judicial notice of the examination report that I received from the Russ State Hospital dated April 8th of 2026. That's an 18-page document. It's the trial competency evaluation report, which was done by the evaluator, Dr. K-A-N, goes through everything that she reviewed, as well as medications, and the fact and her finding also is that he is still not competent to stand trial and requires ongoing hospitalization to manage his risk to himself and others. Also, I have physician's certificate of medical examination for mental illness from a Dr. Tis, T-S-Y-S-S. The finding in that report is that Mr. Fields is mentally ill and suffering severe and abnormal mental, emotional, or physical distress, and that further inpatient treatment would be required for additional competency restoration attempts. There is a second physician certificate of medical examination for mental illness prepared by Dr. Owen, O-U-A-N. They all have such difficult names. And that has that same finding that Mr. Fields is currently mentally ill and also suffering severe and abnormal mental, emotional, or physical distress, and that further inpatient treatment would be required for competency restoration. Okay, that's it. Is there any other evidence with regard to competency?
No, Your Honor.
Like, then at this time, based on the two physicians' examinations for mental illness, as well as the trial competency evaluation report, that Mr. Fields is still not competent to stand trial. Further inpatient treatment is warranted for competency restoration. Going to order him to remain in the appropriate facility for a period of not to exceed 1 year for competency restoration, and we will await any report at that time. We probably need to start looking at the dates, maybe on this.
I looked at that this week, Your Honor.
It's a second degree though, I guess, so.
Well, it's enhanced to a second. As indicted, it's a third, I believe.
Okay,
And if we're going to consider dismissal, want to make sure something's in place civilly.
yeah, if you'll kind of start taking a look at that, I think we're just a year out from the 10 years.
That's correct.
And so by the next setting next year, we'll need to have that looked at.
Certainly.
All right, thank you. This Holmes on Michael Keller.
Alrighty, friends, let's go back to Judge Boyd's court and we will finish off our day there.
State versus Stephen Limon. Can I have parties announced?
Renee Munoz on behalf of Mr. Limon.
And are you Mr. Limon?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Mr. Limon, did you review the application for community supervision with your attorney? Did you understand it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your
Counsel, do you waive the reading of the indictment?
Honor. Yes, Judge.
State, are you proceeding on the indictment as presented? Court will find that the state is in compliance with discovery. Mr. Limon, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with driving while intoxicated, third or more. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
That is correct.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Limon, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 8 years in the prison. There's a $0 fine. The state is recommending community supervision. This is running concurrent with 2025 CR 007431. Restitution, if any, and 2-year driver license suspension or affidavit of non-driving. Did you understand that to be your plea?
Yes, Your Honor.
Defense state?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Any such motions?
Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 200 hours community service restitution, 10 days in the Bear County Jail, participation in the felony drug court, DWI intervention, VIP live, and ignition interlock for half the term. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
To the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
No objection.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, and most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. All right, proceeding with sentencing.
Yes, Your Honor.
And I'm assuming he's already been accepted into felony drug court?
He has, judge, in that case that is to run concurrent is also a case that he's currently on.
All right. So here's the thing. And I know I probably told this to you before when you were placed on probation. You can't drink alcohol, period. And if you continue the way you are, one, you're going to end up destroying your liver. And then you're going to be on some site asking for somebody to donate a liver. You're going to destroy your kidneys, or you may end up killing someone. You understand? And I understand that you have military service, but any issues that you have that's related to that, you're going to have to start addressing those and not through alcohol, because otherwise it's not going to end well. You understand?
Yes, Your
All right. This is what the court will do. The court is going to sentence you, as previously stated, the court, I'll state you may be excused. As previously stated, the court is going to find you guilty. The court is going to sentence you to 8 years in the prison, suspended and probated for 5 years. There's to be regular random UAs, regular reporting by Zoom or in person, proof of employment within 45 days of release, no employment as a home health care provider or with minors. He's to remain in custody, counsel, until released by felony drug court.
Yes, Your Honor.
There's to be a 2-year license suspension. This is to run concurrent with 2025 CR 007431. 200 hours of community service restitution. I'm going to deduct an hour for every sober support meeting that's completed. Field visits 1 time per month until further notice. DWI intervention, DWI education, VIP live, restitution, if any, to Paul Sparks. Ms. Ferguson, I need a restitution date. State, how long will it take to get restitution?
2 weeks is fine.
All right, can you set it 3 weeks? All right, that'll be May 26th for the restitution hearing. And I assume they said in here that they would allow an affidavit of non-driving, but what I'm gonna tell you, if you have access to any vehicles, like it's in your parking lot, I don't care if it's somebody you're living with and it's their vehicle, then for the court, you have access to that vehicle and that vehicle will need ignition and interlock. You understand? All right, so
Your Honor, one quick question, regarding the restitution hearing. If he is in an inpatient facility, can he appear through Zoom?
yes. So that's ignition interlock. Full term. Or affidavit of non-driving with proof of no access to vehicles. And probation, I know it's hard for people to prove a negative, but once you all go to the home, you'll be able to see if he has access to vehicles. So it's ignition interlock full term or affidavit of non-driving with proof of no access to vehicles. And that will be with a portable alcohol monitoring device. 10 days in the Bexar County Jail as a condition of probation. Probation, is there anything else? Is there anything else you need from the court to be successful?
Thank you.
You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, so here's the thing. You got to figure out why you're using, and you've got to figure out what works for you to maintain your sobriety. And if there are people who are around you who realize that you shouldn't be drinking, and they tell you, oh, it's just one drink, those are not your friends, and you're going to have to cut them off. Your sobriety needs to be your number one priority, okay? All right, good luck to you, okay?
Thank you, John.
You're welcome.
Okie dokie, friends, that will do it for today. We'll be back. Well, not for today. We'll be back tonight, 8 p.m. Eastern, 5 p.m. Pacific for Sidebar right here on this channel. So join us for that. And then we'll be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific. I hope you all had fun. I appreciate you joining me. Go have yourselves a great day, and we'll see you soon. Take care. God bless.